A very good morning to one and all on the e-platform of Faculty of Law, GLS University. Today we have an esteemed guest with us to judge the final round of Intra Moot Court competition, Honorable Miss Justice Harshaben Devani and Honorable Mr. Justice S.D. Shah, former Judge High Court of Gujarat. Uh, Very first, I would like to tell our director, ma'am, to propose the welcome address. Ma'am is a member expert expressal committee.
Vidhiman, thank you. Vidhiman, good morning. Thank you.
Okay, ma'am.
It is my pride and privilege to welcome honorable judges of today's intra competition. We are very much thankful to both the esteemed judges for accepting our invitation. Uh, it is always said that a judge, a judge is like a diamond sharp and a diamond heart. And today, both the judges who are with us today, they are diamonds in their field, being judges. Two unique characteristics of both. Honorable Miss Justice Devani ma'am, she is bright alumnus of GLS. So it is always, we feel proud that she is part of the GLS family. And she has today accepted our invitation to judge this intra court. One very unique thing about ma'am is that she is very humble, very hardworking, and the best example that even if you do not have any law background, because usually it is said that if you have a law background, then only it is easy for you to shine out. But I think ma'am is exception to that. That though she do not have any law background, she has achieved the heights in legal profession. Ma'am, I heartily welcome you on this platform of Faculty of Law, GLS University today.
Thank you.
With Devani ma'am, we have Honorable Mr. Justice S.G. Shah sir. Shah sir, when we were discussing with the faculties, and as this program was on e-platform, so I told Vidhi that S.G. Shah sir is the person that post-COVID now people are more sensitized for the ICT and all that. But he is the man behind ICT in Gujarat High Court and to certain extent I will say Supreme Court also. Because now we are talking for the paperless courts, but I think Honorable Mr. Justice Shah's contribution for paperless and for the ICT is enormous. So I welcome you on this e-platform. Today, this is the Intra Moot, and the best of the best teams, they represent GLS at the various national and the international moots. So this event is very, very, very important for the entire Faculty of Law family. Once again, without wasting time, I once again welcome both the honorable judges.
Thank you. Thank you, madam. Thank you.
Thank you, ma'am, for a very warm welcome of our esteemed judges. Now I take the privilege to introduce our esteemed judges of the event. Honorable Miss Justice Harsha Devani, ma'am, is a postgraduate in science and did her law from Sir Elisha Law College. Ma'am enrolled as an advocate with Bar Council of Gujarat in the year 1992. Ma'am's rich experience reflects his tenure as an assistant government leader and assistant public prosecutor. Her moral excellence and analytical skills enabled to have a mastery in constitution, civil and criminal matters. Ma'am has elevated as an additional judge of Gujarat High Court on October 2004 and confirmed as a permanent judge on August 2007. Ma'am rightly stated that a very unique characteristic of Harsha ma'am is a very meticulous person, very hardworking, and always give opportunity to both the party to hear very patiently. We heartily welcome you, ma'am. And
Thank you.
Honorable Mr. Justice S.G. Shah, sir, is again a science graduate and holds a master degree in law. Sir was enrolled as an advocate in 1981 and continued his practice as an advocate till February 1997. During his period, Sir practiced almost in all the sides civil, constitution, revenue, etc. In the various courts, tribunals, and the commission. Sir is among the first law advocate who had adopted the computer technology in the back 1985. In 1997, Sir was directly appointed as a judge of a city civil court and the session, and was sent to Supreme Court of India for classification of cases at Supreme Court. Sir is instrumental in implementing the project of computerization in new Gujarat High Court complex. During his service as a registrar, Gujarat High Court, Sir has worked as administrative side for infrastructure requirement for an entire state judiciary. Sir was appointed as a special judge, CBI Court, and was appointed as a registrar court and computer, Supreme Court of India on deputation. Sir was elevated as an additional judge, Gujarat High Court, on November 2012 and confirmed as a permanent judge in July 2014. Uh, it has been heard from the lawyer's friend that Sir is very favorite in the junior lawyers, and everyone loves to argue in front of the Sir. So today, Sir, the budding lawyers is also awaiting for it. Uh, if the judges permit, shall we have a virtual court in session?
Certain, please.
Yeah. Sir, so the very first team, appellant one, we will be taking it in the studio, right? Okay.
Ma'am, should I proceed?
Just a minute, just a minute. Yes. Oralist one can proceed.
Your Lordships, the Council appears on behalf of the appellant. If your Lordships are well versed with the facts for the sake of brevity, may the Council address your Lordship with the issues directly?
Yes.
Your Lordship, the issue number one being whether the Honorable Court has a jurisdiction to entertain and decide the club petitions together in the scope of interference with the writ jurisdiction of the Honorable High Court. Addressing the same, the appellant humbly subjects that yes, this Honorable Court has a jurisdiction under the ambit of Article 227 being the supervisory power to interfere with the remedies laid down by the subordinate court. Further, it is submitted that if the grievance of the petitions are co-associated with one another, the Honorable Chief Justice of High Court has the power to allow the case to a single judge to take up to two distinct matters under two different laws along for the better administration of justice. The same is being reiterated in the appellate side rules, being the Honorable Chief Justice of High Court as per the rules conferred under the Rule 127 of the Gujarat High Court Rules 1993 can do the same. Thus, it is submitted that the Honorable Chief Justice of High Court has the power to club two distinct matters under two different laws for better administration of justice as well as under the ambit of Article 227 of the Constitution of the India. The High Court has the power to interfere upon the impugned judgment passed by the subordinate courts. Now, your Lordships coming forward and addressing issue number two, being whether the sexual relationship based on the consent given for the promise of marriage be termed as sexual abuse, in the jurisdiction of this court to give remedies for the same. In the present petition before this Honorable Court, it is humbly submitted that the subordinate courts erred in arriving at the judgment laid down by them, as they did not take into the purview the recent judgments laid down by the apex court, where if the promise of marriage was given and upon which if a woman gives consent to sexual relationship and the said promise is not fulfilled, then the consent given at the time of the promise of marriage stands vitiated. Further, it is submitted that in the present petition, the respondent had mutually consented to get married, but were unable to. Due to the respondent stating that he was already married and was awaiting divorce by mutual consent from his erstwhile wife. The said statement given by the respondent as well as the act of the respondent in moving together with the appellant in another town and cohabiting as husband and wife gave assurance and reinforced the belief in the promise given to the appellant. For the promise of marriage and cohabitation had started the respondent in the first place, relying upon the promise of marriage, given which is an unassailable fact. Thereafter, in October 2010, the respondent was legally separated from his erstwhile wife, but did not take any steps towards getting legally married with the appellant, but enjoyed full conjugal rights with the appellant. The assurance and belief grew stronger as the respondent got legally separated. It is submitted that the promise of marriage was being lingered by the respondent. In the meantime, by November 2013, a child named Ritansh was born in this relationship. Thereafter, the appellant had visited the paternal side to attend sister ceremony with the child. Once there, the respondent, seeing that the appellant had stayed there for a period of 10 weeks, and the thought of paternal family accepting the child in the relationship, the true malai started pouring out of the promise made in lieu of marriage. Thereafter, the respondent, upon the return of the appellant, refused to keep her and maintain distance from the child, and appellant forcing the appellant to move to another place of rented residence. That the respondent, acting on sudden whims of making a promise of marriage, and suddenly acting on the whim of refusing to accept the appellant, even after a child is born out of this relationship, rendering the appellant and child's life being ruined. That such feudal mindset and male chauvinism that women are an object of enjoyment, that a promise of marriage can be given, is required to be rigorously addressed and strictly dealt with in order to create a healthier society and to increase a sense of security and protection in the mind of the woman. It is submitted that this honorable court should take into consideration the social reality of human life and give protection to the appellant who has suffered on account of false promise of marriage. It is submitted that the false promise of marriage for obtaining consent for sexual intercourse falls under the ambit of Section 90 of IPC as interpreted in various judgments of the apex court. And it is not a valid consent in the eyes of law and is to be charged under Section 375 of IPC. Further, Your Lordship, further it is submitted that false promise of marriage for obtaining consent for sexual intercourse is considered as a misconception of a fact within the meaning of Section 90 of Indian Penal Code 1860. Thus, it is not considered as a valid consent in the eyes of the law and would be charged under Section 375 of the IPC. The second explanation of the Section 375 of IPC provides punishment for rape if sexual intercourse is done without victim's consent. However, the Honorable Apex Court, along with Honorable High Court, have stated that have started taking a different approach towards Section 375, interpreted the term consent in a broader way. However, the law is very clear in this regard that a false promise to marriage amounts to rape and comes within the ambit of Section 375. There are various judgments citing that false promise of marriage does not amount to rape, but in all those cases, a reasonable apprehension was there, which was stated in the facts. A reasonable apprehension in the minds of the victim, whereby she knew that on the basis of caste, on the basis of denial of family, on basis of any other reason, the marriage could have not occurred. But in the present petition, there was no reasonable apprehension on the mind of the appellant, whereby she could conclude that no, at any instance of time in future, the marriage could have not been occurred because the act of the respondent itself was to cohabit with her. After that, he really got legally separated from his first wife, and thereafter, they had a child born in such a relationship, which gives a reinforced state of mind to the appellant, whereby she was secure that no, since the respondent is doing all these acts, he may marry him, but there was no apprehension that he might not marry him in the next future. And just on the sudden whim that falling out of love or falling out of love and not marrying the same person, a promise given in the prior year and then not fulfilling it in the past, does not allow the respondent to just play and escape from the garb of false promise of marriage.
May I ask the question at the time when you started living together,
yes,
was he married or not?
He was married, Your Lordship.
Were you not aware of the fact that he is married?
Yes, being aware of the fact he was.
Despite that, you entered into a relationship with him.
Yes, Your Lordship. At that time, he was not.
Where is the misconception of fact there? When you
yes, Your Lordship.
Yes, so he was a married man.
Yes.
You see, from the facts that come on record, there is nothing to show that he is yet divorced.
Yes.
So the situation is still the same as it was at the relevant time.
Yes, Your Lordship, but then thereafter he did get legally separated. And even after...
Did he get divorced? Because legal separation does
not
amount to divorce.
No, he got divorced. He got divorced under mutual decree of section 13B of Hindu Marriage Act.
Okay.
And thereafter, the cohabitation had continued. And thereafter, the child was born. And even in the case, Your Lordship, where I have cited, where even if the husband and wife marry other people, but there was an instance where the woman has alleged that no, there was a sexual abuse. That does not mean that even both of them are married. We can escape from the charges alleged against him. Even further stating that Section 114 in the Evidence Act provides as follows: that the presumption as to absence of consent in certain prosecutions for rape, thereby it is held that whether it was without consent of the woman alleged to have been raped, and she states in her evidence before the court that she did not consent, the court shall presume that she did not consent. Further, the reliance is being placed on the judgment laid down by the Honorable Apex Court in the case of State of UP versus Naushad, whereby it is stated that the sexual intercourse on the false promise of marriage would amount to be without consent and would fall in the second clause of the section 375 of the IPC. Further, even the reliance is placed on the Yedla Srinivasan Rao that the intention of the accused is to be taken into consideration. The intention of the accused from the very beginning was malafide, and he had sexual intercourse on the false premise to marry the prosecutrix. Even in the case of Harshvardhan Yadav versus State of UP, it was stated that the sum and substance of the official decision, the same case, Your Lordship, that I cited, that when two people were married to each other, but on the later stage, but still the alleged allegation was upheld and was proved. And Your Lordship, coming to the latest the latest judgment that has been passed by the Supreme Court in the year 2019, the heavy reliance is being placed on the state case Anurag Soni versus State of Chhattisgarh, being on page number 24. If an accused from the very beginning did not intend to marry the victim, but gave false promise to marriage, to and in lieu of such promise that the accused will marry her, she gave her consent for sexual intercourse with the accused, then such consent would not amount to be valid consent, and therefore comes within the ambit of misconception of fact under section 90 of IPC. Your Lordship, the court has evolved its view from 2008 in delivering judgments to 2019. By the year 2019, they have come to they have opined that no, there have been cases where there are genuine cases where the false promise of marriage is being made and the promise is not being fulfilled, and thereby in 2019 they stated that if a promise was made, though in the prior date, it has to be fulfilled, and if it is not being fulfilled, it will amount to sexual abuse. Even in the Anurag Soni, para 19, Your Lordship, on page number 25 states the same. Hence, Your Lordship, it is humbly submitted that there was a false promise of marriage made by the respondent number 1, which was never fulfilled and had no intention of being fulfilled. And further, this relationship was known by all relatives and friends and neighbors and colleagues, which further reinstated the faith of promise of marriage given by respondent number 1 to the appellant. And there was no comprehensible reason or belief that the appellant to believe in the far-fetched realm that the promise of marriage was never to be fulfilled. So there was no reasonable apprehension in the mind of the appellant, whereby even it can be stated that no, at any certain point of time in future, the marriage would not have occurred. Your Lordship, coming to the issue number 3, that can any order be passed by the family court in respect of the custody of minor Mitansh? Your Lordship, the appellant humbly submits that this honorable court should pass an order restraining the family court on adjudicating the matter before it, as the appellant has come before this honorable court challenging the rejection order passed by the family court. And once the appellant is before this honorable court challenging the impugned order passed by the family court, the honorable high court has taken the cognizance for it. And thus, Your Lordship, my co-counsel will go ahead with the another issues.
I request everyone to stick to the time. I request everyone to stick to the time. Each appellant is getting 5 minutes time. So please stick to the time. The judges have a discretion to give a negative marking. Lordship, now the appellant 1, oralist 2 is speaking.
Okay.
Your Lordship, my learned friend has dealt with issue 1, 2, and 3, and the co-counsel would proceed with issue number 4. Your Lordship, my issue number 4 is addressed such as that whether a live-in relationship would fall within the purview of relationship in the nature of marriage. Your Lordship, it is humbly submitted that Domestic Violence Act 2005 is considered as the first legislation which has recognized this right. Your Lordship, under section 2F of the same act, domestic relationship is defined, which includes relationship in the nature of marriage. Your Lordship, now to support my contention, the counsel would argue one case which is Indra Sharma versus VKV Sharma, in which the Honorable Supreme Court has laid certain guidelines, and under such guidelines that for testing the circumstances that under which a living relationship would fall within the expression in the relationship of marriage. The council will show that how these guidelines are relevant to this present case, and each and every guideline is fulfilled. The first guideline being the duration of period of relationship. In this present case, it is 4 years, Your Lordship. The second is said household. Both appellant and respondent number 1 were living together in a rented apartment since 2010. Third is pooling of resources and financial arrangements. Both appellant and respondent number 1 has opened their drama school as a joint venture, and both of them were earning their livelihood from the same school. Fifth is children. Fourth is domestic arrangements. Sixth is socialization in public, and seventh is intention and conduct of parties. Supreme Court has said that if there is a children born out from the said relationship, then it is a strong indication. In this present case also, they both have their child named as Mitans, born from the said relationship, and therefore, Your Lordship, all the 7 guidelines which are laid by the Supreme Court is fulfilled in this present case, and therefore the council humbly submits that this relation should be treated as the relationship in the nature of marriage as given in section 2F of the same act. Your Lordship, furthermore, to cite one more case, in the year 2010, the Supreme Court in the case of Madan Mohan Singh has held that if the living relationship is continued for a long time, then it cannot be termed as walk-in or walk-out relationship, and that there is a presumption of marriage between both the parties, in which once again section 114 of the Indian Evidence Act comes into play. Section 114 of the Indian Evidence Act talks about the presumption of marriage if parties have lived together as husband and wife, and it is for the in this present case, it is for the respondent number 1, the husband, to prove that if he wants to deprive the status of this legal origin, and therefore, Your Lordship, the council humbly submits that both the legislature and the judiciary have acknowledged the living relationship, and therefore this present relationship should be treated as relationship in the nature of marriage. Your Lordship, my sub issue being that whether talks about the rights of maintenance and residence which are available to Anvita. Your Lordship, it is humbly submitted that the relationship between the appellant and respondent should be treated as domestic relationship, which is given under section 2F, and therefore, Your Lordship, the council would refer one case which is Chanmuya versus Chanmuya Kumar, in which the Supreme Court has stated and the Supreme Court has observed that the broad interpretation of the term wife should be done in this as constantly there are social changing values. And Your Lordship, the Supreme Court has held that the definition of wife includes a woman residing in a shared household in a domestic relationship, and therefore in this present case also the term wife will include the present relationship and the appellant. Your Lordship, now furthermore, it is in this case only the Supreme Court has observed that a girl can claim maintenance under section 20 of the Domestic Violence Act also, and also under the section 125 of CRPC. So in this present case, the appellant can claim maintenance under both the statutes, 125 of CRPC also, and again for 120 of the Domestic Violence Act. Now furthermore, in the year 1999, in the case of Rajati versus Ganeshan, the Supreme Court has said that section 125 is enacted on the premise that is the obligation of the husband to maintain his wife. In the present case, appellant, the respondent number 1 refused to maintain the appellant, and therefore if respondent number 1 wants to deny this fact, it is the burden lies on the respondent to prove that he did not neglect appellant number 1, and therefore it is humbly submitted that the appellant is liable to claim maintenance under both these statutes. Now, Your Lordship, coming for the rights of the children, Mitans, Your Lordship, for the sake of brevity and the time, the council would only refer one case, which is Tulsa versus Durgayata, in which the Supreme Court has held that if both the parties are living together under one roof and if they have cohabited for a long time, then it is to be presumed that the child which is born in from such relationship will be considered as legitimate child, and it will not be considered as illegitimate child, and therefore, Your Lordship, all the rights which are given in this, which are in the Domestic Violence Act, should be given to Mitans, as Mitans will be considered as the legitimate child. And therefore, Your Lordship, this concludes my 4th issue. Now, moving on to the 5th issue is, Your Lordship, that whether Anvita is entitled to share of profit arising out of said drama school. Your Lordship, it is mentioned in the fact sheet that both Anvita and Naveen, the appellant and the respondent number 1, started drama school as their joint venture, and both were earning their livelihood from the same school. And therefore, both the subordinate courts.
I'm putting a query. Under which provision of the Domestic Violence Act can she claim? Under which provision?
Under section 20. Under section 20.
Under section 20, what can she claim? She can claim compensation.
Under section 20, she can claim. Yes, she can claim compensation. She
But
can claim monetary relief for the
can she
maintenance.
claim a share in the partnership or in the joint venture?
That is not under Domestic Violence Act, your lordship. That is a joint venture, and therefore a oral agreement is valid, your lordship.
So how do
And
you claim it
therefore,
under the Domestic Violence Act? Your application was under
no,
the
no,
Domestic Violence Act. Then
this application was under Domestic Violence Act, but your
how do you
lordship,
claim a share in
in
the
the lower
property under
courts,
that application?
Because your lordship, in the present case, appellant and both the respondent have started as a joint venture as their drama school, and the respondent number is not giving the legally entitled share of a profit, and therefore both the lower courts, both the subordinate court, in their order, which is the impugn order, which is the past, both the courts have held that the respondent number one is directed to pay the amount of 1,50,000 as it was joint venture, and the appellant is liable for the same, and therefore the courts have rightly held that the counsel herein in the High Court only says that there should be strict compliance of the said order, your lordship, and therefore the council seeks for the compliance of the said order, because both the subordinate courts have held uh, the compensation from which is the profit which is arising from the drama school should be claimed, and therefore your lordship, the council humbly prays that to set aside the impugn order passed by the subordinate courts, as much as it is against the petitioner, may pass the order to stay the proceedings pending before the family court till the final disposal, may pass the order of injunction as prayed in the present petition, interim maintenance may be provided, and any other relief or directions of that this honorable court may please to grant in the interest of justice, equity, and good standing. Highly obliged.
Am I audible, my lords?
Yes.
Yeah, your lordships, this is counsel number one appearing on behalf of the respondent. Lordships, the proceedings at the first instance have been initiated before the judicial magistrate first class under the provisions of the Domestic Violence Act, and the same have arrived before this honorable court by way of a criminal writ petition. Your lordships, in addition to this, the petitioner has also filed a civil writ petition challenging the interlocutory order passed by the honorable family court. Now, your lordships, coming to the issues, the first, fourth, and fifth issue will be dealt by me, whereas the second and the third will be dealt by my co-counsel. If, with your lordship's permission, moving on to the first issue.
Yes.
Oblige.
Yes.
Your lordships, the first issue is whether the Honorable High Court of Gujarat has the jurisdiction to entertain and decide the aforesaid petition together, and what is the scope of interference. Your lordships, in my respectful son, the criminal writ petitions can be clubbed together since the order under challenge arises out of a common influence order, and the same has been in the similar nature. Your lordship, the subject matter of the case is also similar in nature. Your lordship, whereas on the other hand, the civil writ petition which is challenging the interlocutory order passed by the family court cannot be clubbed with the criminal writ petitions. Your lordships, in the with regards to the scope of interference, the law laid down by the Honorable Supreme Court in the cases which are cited at page number 14 and 15 are applicable in the present case, and the Honorable High Court has jurisdiction under Article 227 and 226 of the Constitution to entertain such petitions. Your lordships, in these referred cases, the Honorable High Court has the powers to entertain the writ petitions wherein the orders are passed exercising the powers which are ultra in nature to the powers which are conferred on the such authorities. Your lordships, moving with your lordship's permission, moving on to the fourth issue.
Yes.
Oblige, your
Keep
lordship.
continue.
Your lordship,
Continue your submissions.
much obliged. Your lordships, to the fourth issue, as to whether Anvita is entitled to the share of profit arising out of the activities of drama school. If yes, can Naveen be directed by the court to pay such share? Your lordships, in my respectful submission, any relief which has been claimed under the Domestic Violence Act can only be claimed when there is an occurrence of a domestic violence. Your lordships, the term domestic violence has been clearly defined under section 3 of the Domestic Violence.
You are not very audible.
Furthermore,
Yes.
am I audible, lordships?
Yes. Now it's okay. Now you are audible. You're audible.
Your Lordships, the petitioner does not even fall under the purview. Yes, Your Lordships. Your Lordships, the petitioner does not even fall under the purview of Section 2, subsection. It clearly defines the term aggrieved person. Your Lordships, furthermore, in the case of Aarti Sharma versus Gagan Saran, the Honorable Delhi High Court in a very recent judgment has stated that a civil dispute relating to the ownership of property cannot be converted in this manner into a case under the Domestic Violence Act, and the same would amount to an abuse of the beneficial provisions of the Domestic Violence Act, which is stretching it over and beyond its purpose and ambit. Your Lordships, various other honorable high courts on various occasions have stated that the disputes which are relating to the property, the title or ownership of the property are to be adjudicated only by a civil court. And your Lordships, in the present case, the criminal courts have exceeded their jurisdiction. Lordships, now finally moving on to the fifth issue as to whether any order can be passed by the family court in respect to the custody of minor Mitans at this stage by proceeding with the custody application during the pendency of petition before the Honorable High Court. Your Lordships, in the present case, the petitioner seeks to challenge the interlocutory order whereby the family court has rejected the application for stay of the proceedings in the custody application which has been filed by the present respondent. Your Lordships, in my respectful submission, the learned family court can very well pass the order in respect of the custody on the following grounds. So, Lordship, firstly, the section 19 of the Family Court Act clearly bars any challenge of the interlocutory order of the family court. So, Lordship, secondly, the subject matter of the criminal writ petitions which are pending before this court are altogether different and arise out of a different cause of action. Your Lordship, there is no similarity in these criminal writ petitions as well as the civil writ petitions. Thirdly, Your Lordship, this honorable High Court has not granted any stay to the family court to not to proceed with the issues. And Your Lordship, fourthly, in various landmark judgments which are cited on the page number 33 and 34 of the memorial, the Honorable Apex Court as well as various Honorable High Courts have observed that any interlocutory order which is passed by the family court cannot be challenged before the Honorable High Court. Lordship, I fail to understand under what jurisdiction the petitioner is filing such civil writ petition challenging the interlocutory orders. Lordship, in view of the above, the family court can very well proceed with the application as such. Lordship, the council seeks the leave of this court as the issue number 2 and the 3 will be dealt by my co-counsel. It was a pleasure arguing before this honorable court. Much obliged.
Yes.
If your lordships do not have any further preliminary inquiry, the council number 2 seeks permission to proceed towards issue 2 and 3. Much obliged, your lordships. Your lordships, issue number 2 in hand is whether or not the relationship between the parties, based on the consent of Anvita, can be termed as sexual abuse, and whether the Honorable High Court has the requisite jurisdiction to entertain such issue. Your lordship, my co-counsel has already dealt with the issue of maintenance. The council hereby would like to submit her submissions that in no case did the relationship between Anvita and Naveen amounted to any sexual abuse whatsoever, your lordship, because there is no dispute whatsoever in the present case that the respondent in any way made any false promise of marriage to the petitioners, your lordships. Your lordships, the council would humbly bring to the kind notice of this honorable court that till 2013, even when Mitansh was born, the relationship between the parties was very cordial and accommodating in nature, and it was based on mutual love and consent. It was only after Mitansh was born, the petitioner itself never even intended or never even suggested the proposal of marrying the respondent, which clearly points out that the parties were very largely satisfied within their existing relationship and there was no longing of marriage whatsoever from either end. Your lordship, is, with the permission of the honorable court, the council would hereby rely on a couple of judgments passed by the honorable Supreme Court as well as this honorable High Court itself, which clearly points out what constitutes misconception of fact under section 90 of IPC, as has been claimed by learned counsels for petitioners. So, in the recent case of Pramod Pawar versus State of Maharashtra, wherein the facts are squarely similar to the facts of our present case, Honorable Justice D.Y. Chandrachud held that to establish that the consent of a woman for a physical relationship was obtained by fraud and misconception, it was necessary to show that the man gave a promise in bad faith and never had any intention of marrying the girlfriend. Your Lordship, it is most respectfully submitted that at the time when the petitioner moved in with the respondent, she was very well aware of the fact that the respondent was not even divorced, and hence a question of legal marriage did not even arise, which clearly points out that the relationship was was desired to be more of a live-in mutual cohabitation rather than a nature of marriage. This was confirmed by Honorable Delhi High Court in the case of Sujit Ranjan versus State, Deepak Gulati versus State of Haryana, and many others, including Sejalbane versus State of Gujarat, by this Honorable Court itself, Your Lordships. Further, Your Lordships, the Council hereby submits before this Honorable Court that this is nothing but a case of frivolous litigation, as has been held by Honorable Justice Dalveer Bhandari in the case of Rameshwara Devi versus Nirmala Devi, wherein Justice Bhandari held that unscrupulous litigants can till eternity harass the respondents by abusing the judicial system, which was confirmed again by this Honorable Court itself in the case of Sejalbane Chovatia versus State of Gujarat, wherein it was found that such litigations must be punished for unscrupulous claimants with fines so that justice is served. Moving on to the sub issue that the counsels for the learned counsel for petitioner are trying to bring this case into the ambit of sexual assault, marital rape, and misconception of fact, Your Lordship, it is most respectfully submitted that these submissions are nothing but preposterous, both in fact and in law, because the present relationship is nothing arising out of a sort of a marriage relationship, and the question of marital rape does not even arise in the present case. Now, if Your Lordship would permit, the counsel seeks permission to proceed towards the third issue.
Yes.
Much obliged, Your Lordships. The third issue in hand is whether Anvita is entitled to claim maintenance for herself and the child in a relationship which is not marriage but in a nature of marriage. Your Lordship, before moving towards the issue of maintenance, the Council would humbly like to point out a couple of points which the Learned Counsel for Petitioners have very conveniently made before this Honorable Court. The first is to claim maintenance under Section 125 of CRPC. The relationship should be marriage, a legal marriage, and not a relationship arising out of a nature of marriage. The councils have relied on the case of Chanmunya versus Virendra Kumar as well as Abhijit versus Maharashtra in their submissions, for which the council would humbly point out that the present cases had different sets of facts. In the present case, Chanmunya versus Virendra Kumar, there was a marriage which arose out of social customs and not out of under Hindu Marriage Act, and hence the Honorable Court held that those marriages can be included into the ambit of a legal marriage, and hence a legal relationship was valid. This was not the case here, Your Lordships. Further, with respect to the issue of maintainability of Mitansh, the petitioners are the respondents are in no way shying away from their responsibility of maintaining Mitansh, Your Lordship. It is nothing but wasting a precious time of court for bringing this issue in hand, because, Your Lordships, the respondent has already filed an application for custody of Mitansh. The question of maintenance would arise only after the custody has been decided and not otherwise, which
Just a moment.
again has...
Okay, just a query. Since when are you separated? Since when has Anvita left you?
This particular
So what is-
itself,
No,
year
so-
itself, Your Ladyship.
So have you paid any maintenance for the child so far? How is she maintaining him?
Your Ladyship, the council, that at the moment the separation occurred, the council very well filed the custody of Mitansh, Your Ladyship.
You filed the application for custody at a later stage, not immediately. So in the meanwhile, how was she supposed to maintain Mitansh?
Certainly, Your Ladyship. The honorable judicial magistrate as well as the Sessions Court has already ordered the respondent to pay a share of profit arising out of the drama school, which the respondent is complying until under protest this order has been decided by this honorable court, Your Ladyship.
Yes, you can proceed.
Much obliged, Your Ladyship. Your Ladyship, at the end, the council submits that in the case of Sanjay Bharadwaj versus the state, the honorable, if the council could conclude in 2 minutes, Your Ladyship. Much obliged, Your Ladyship. The council permits that in the case of submits that in the case of Sanjay Bharadwaj versus the state, the honorable court has held that a wife which is legally capable and decent enough to maintain herself can no longer sit idle in virtue of anticipation of claiming maintenance, Your Ladyship. In the present case, Anvita was very well working into a drama school and a media house and is very capable of maintaining herself. And the relevant observation made by the court was that in the constitution we are living in the era of equality of sexes, and an unemployed husband would be considered at the same footing with an unemployed wife and cannot be cannot be asked frivolously to maintain the wife. Hence, Your Ladyship, at the end, the council rests the submission by submitting before this honorable court that the question of maintenance under Domestic Violence Act do not arise because, one, there was no domestic violence whatsoever; two, Anvita was well capable of maintaining herself; and three, the question of maintenance under Section 125 here holds no ground because the parties were not legally married to each other, and the petitioner, the respondent, has never denied his responsibility to maintain Mitansh, your ladyship. Now, with the permission of the Honorable Court, the Council seeks permission to proceed towards the prayer.
Yes.
Much obliged, your ladyship. Much obliged, your lordships. Therefore, in the rights of issues raised, arguments advanced, authorities cited, the counsel for the respondent humbly prays before the Honorable Court that the court be pleased to adjudge, hold, and declare that your court may be pleased to partly uphold the order passed by learned judicial magistrate and sessions court, holding that the petitioner is not entitled to claim maintenance from the respondent, that the court be pleased to partly uphold the order passed by learned judicial magistrate and session court, holding that there is no sexual abuse committed by the respondent on false promise of marriage, that the court be pleased to quash and set aside the part order of the magistrate and session court which held that the respondent is liable to pay the share of drama school, that the court may be pleased to dismiss the civil writ petition filed by the petitioner challenging the refusal order of learned family court to adjourn the matter, and any other relief that the honorable court may be pleased to grant in the interest of justice, equity, and good conscience, all of which is most humbly submitted before this honorable court, and for this act of kindness of your lordships, the respondent shall as duty bound forever play. In respectful submission before the Honorable High Court of Gujarat, the Council's rests for submissions here. Much obliged, your lordships.
Your lordships, may I proceed with the rebuttal?
Yes.
Your lordships, the learned counsel for the respondent has stated that since the past, the appellant had moved away from the respondent in the year 2014 till the year 2021 when this case is filed, the petition is brought before this honorable court. They are saying that they are not liable for maintenance. In another statement where they are saying that she is well educated and earning, she is not getting her own right from the drama school, which was a joint venture. How come they come and tell that she has all the assurances and all the sources for her own maintenance as well as the child's maintenance? Further, this honorable apex court has ruled in certain cases where in section 125 CRPC, in Abhijit Singh case, that is cited in issue number 4 in our memorial, thereby it is said that claim that it is not necessary for a woman to be a wife or legally wedded to claim maintenance under section 125. Domestic Violence Act 2005 itself states that under section 2A, who can claim maintenance, who has lived in consanguinity with the partner. And even in the cases that she has cited in our memorial, the cases were that no Hindu marital ceremonies were performed, but yet it is stated that even though they have lived akin to husband and wife, as the case stated, all the 7 requisites are being fulfilled, they are to be construed under the meaning of common law marriage as per the judgment of 1925 of Privy Council, whereby it was stated when two people are living in a household and sharing the same household and there was no marriage ceremonies performed, then also they are to be considered as a common married couple. So from 1925 to 2010 judgment of C. Chillu Swami, every requisites are being fulfilled. Then on what basis they are saying that she cannot claim maintenance under Domestic Violence Act, and under what purview they are saying that the appellant is not responsible, is not liable for maintenance?
Yes. Is it over? Your submission?
So, lordships, in my respectful submission.
Yes.
May I proceed, your lordships?
Yes. But it is for rebuttal, no? Are you supposed to speak in between?
Yes, your
Yes.
lordships.
Okay.
Lordships, it is a surrogate.
No, there is no surrogender in legal proceedings. Are you through?
The rules of the competition provide so.
Okay. Yes, you can. Yes, you may. You may proceed.
Obliged. So, lordships, firstly, my first and foremost submission is the petitioner has filed the proceedings under the Domestic Violence Act. Lordships, they are continuously claiming the maintenance under the CRPC section 125. Lordships, if they want the maintenance, they should have gone before the criminal court. So, lordships, they have come before the magistrate under the provisions of Domestic Violence Act. Further, your lordships, under the Domestic Violence Act, any relief can only be granted to an aggrieved person. The petitioner has failed to show that they are falling under the category of aggrieved person under section 2 subsection A. Lordships, even otherwise, no violence has been occurred in the present case. How can they even claim maintenance under the Domestic Violence Act?
Would it not fall under economic abuse? Just a moment. Would it not fall under economic abuse because you have deprived her of the share in the joint venture?
Well, your lordship, even with regards to this, your lordship, they may have filed a civil suit before a competent civil court.
No. Economic abuse is found under the Domestic Violence Act. See, economic abuse is
might have.
Yes.
Yes, your lordship, economic abuse is a very well integral part of the domestic violence
Yes,
act.
since you are saying
But
that
your
there is no
lordship,
abuse, that is right.
they have failed to show that. Your lordship, even if we consider that there is an economic abuse, but
Yes.
your lordship, they have not come before this honorable
Established.
court with clean. They have yes, your lordship, they have established the domestic violence, and furthermore, they are claiming the share of profit, which is a civil dispute, and it is to be decided only by a civil court. In addition to this, your lordships, when we are claiming this custody of minor, just to
Yes.
see that on the garb of the minor they are getting the maintenance, they are filing an application to stay the proceedings before the family court. So your lordships, all this shows the malified intention of the petitioner to grab money from the respondent. Much obliged, your lordships.
Yeah, your lordship, if you permit just one submission, just one 10-second submission, if your lordship
No,
may
it
permit.
is not. It is
The
not
competition
allowed.
rules does not
It is
provide
not
it. Yes.
permissible under the rules. We cannot permit.
Not an issue, but they did not address any issues put forward.
Much obliged.
I request A1 and R1
Much
to leave the
obliged.
studio. Yes, I request A1 and R1 to leave the studio. Lordship has a discretion to cut their if the time is out. Lordship has a discretion.
All right, because if we ask questions, then they won't be able to finish the issues. That's the question.
Yeah.
So,
Lordship, can I join A2?
yes.
Okay.
Yes.
May I begin?
Yes. You may begin.
The petition that is being filed before the Honorable. Am I audible, Your Lordship?
Yes, you are absolutely audible.
Yes.
The petition that is being filed before the Honorable High Court of Gujarat. The counsels are here for the appellant. The petition has been filed under Article 226 of the Constitution of India. The counsel may ask for permission to jointly refer the bench as Your Lordship. If Your Lordships are well versed with the facts, may I proceed with my issue?
Yes, you may proceed.
The counsels would be dealing with three issues. The counsels would be dealing with three issues particularly. The first issue being whether or not the Honorable High Court of Gujarat has jurisdiction to entertain both the petitions together. The second issue being whether or not Anvita is entitled as to the rights of a wife and can she claim maintenance under that. And we also have a sub issue in issue 2 which says that whether or not Mitanj, that is the minor child, is entitled to claim maintenance. And issue 3 deals with whether Anvita is entitled to the share of profit arising out of the drama activities. The first two issues would be dealt by me. The sub issue of issue 2 and issue 3 would be dealt by my co-counsel. With the due permission of Your Lordship, I will proceed with my issue 1. Much obliged, Your Lordship.
Yes.
The first issue states that whether the Honorable High Court of Gujarat has jurisdiction to entertain both the petitions together. The council prays in affirmation. In the case of SBI versus Ranjan Chemicals and in the case of Adnan Bilal Mullah versus State of Maharashtra, it is being stated that if a common thread or a common question of fact or law is being found in both the petitions, then the court may order a joint trial of both the petitions. And therefore, in the case in hand, both the petitions are of same nature, and that's why the Honorable High Court of Gujarat has jurisdiction to entertain and decide both the petitions together. Your Lordship, I may proceed with my issue 2. Whether or not Anvita is entitled to same rights as that of a wife, and can she claim maintenance for herself under the same? Yes, the council again prays in affirmation because, Your Lordship, as per section 125 of the CRPC, it states the subsection A and B respectively states that his wife and his legitimate or legitimate child can claim maintenance. Your Lordship, till the year 2000, the ambit of the word wife in this section was that a legally wedded wife. But in the year 2000, the Melimuth committee was set up, and according to their recommendation, a revision was been made in the definition of the word wife, and now it has been extended. The definition of the ambit of the definition has been extended, including the women who were in living relationship and now their husband and now their partners have abandoned them. So our client Anvita is will fall under the definition his wife under section 125 of CRPC. Moving forward, also according to the section 2 subsection F of the Protection of Women from Domestic Violence Act, it states the definition of domestic relationship. It includes through a relationship in the nature of marriage. Now, Your Lordship, the fact that that this term through a relationship in the nature of marriage has not been defined in any of the clause or act, but Supreme Court and various high courts have through their judgments mentioned and described and explained this term and given the meaning to this term. I would like to state few judgments of Supreme Court. Supreme Court in Lata Singh versus State of UP stated that the living relationship, if continued for a long time, may not be termed as a walk-in or walk-out relationship, and there is a presumption of legal marriage. Similar contentions were being found in the A. Dino Hemi versus Bala Hemi case, where the Privy Council stated that if a man and woman are living together, then there is a presumption that there is a consequence of a valid marriage. Also, there was a case named this was the very first case which recognized live-in relationship as a valid marriage. It was the case of Badri Prasad versus Deputy Director of Consolidation. Then, in the case of D. Veluswamy versus D. Pachayamal and S. Khushbu versus S. Kanayamal, also Chanmunia versus Chanmunia case and Indra Sharma versus V.K.V. Sharma, we can find a common trend between all these cases where the courts have come out and accepted and recognized live-in relationship as valid marriage, and they have stated that the women in the live-in relationship can claim maintenance, and so the council would like to pray with the Honorable High Court of Gujarat that Anvita is entitled to claim maintenance for herself and her child, and the same may be granted to us.
Just a query. Just a moment.
Yes,
There's a query. You say that a live-in relationship is like a valid marriage.
Yes, Your
Nobody says that it's in those cases which you refer to, they claim to be married. Here you do
Your
not claim
Lordship,
to
I
be
would
married.
Your Lordship, I would like
Not
to
a
say
claim that you are married or that your relationship is a marriage. Like in those Supreme Court cases, the woman claimed to be married and was not in a position to prove. And the courts held that a long cohabitation is a presumption of marriage unless it is proved otherwise. The foundation of your case in domestic abuse is that he promised marriage to you, but he did not marry you. And that is why sexual abuse. So how do you say
Your
those
Lordship,
judgments
the
apply to you?
councils are not dealing with that issue of sexual abuse.
Yes. All right.
The councils have not taken that issue, and we personally feel that it was all consensual and it was not forceful, and so the councils have not taken that issue.
All right. Okay.
Yes, Your Lordship.
Okay.
Any
You can
further
proceed.
queries, Your
No,
Lordship?
you may proceed. You may proceed.
Okay, Your Lordship. So I would like to state that even in the case of Marvin versus Marvin, the California Supreme Court has given the judgment where they coined a term called palimony that is being given to the women who claim maintenance out of a live-in relationship, and the same was being stated in the case of D. Veluswamy versus D. Pachayamal case. They refer to this issue, and so we can see that there is a trend that is being coming from the foreign courts to the Indian courts, and by this I would like to conclude my arguments, Your Lordship, and I would like to hand over to my co-counsel to deal with the further two issues.
All right. Yes. Yes, you may proceed.
Am I audible, my Lordship?
Yes, you are audible.
Yes, yes.
As discussed by my co-counsel, I would be dealing with the sub-issue and the third issue. May I proceed?
Yes.
Yes.
My sub-issue is whether or not the child born out of this relationship is entitled to maintenance and the property rights. Now, under Section 125 of CRPC, it is clearly stated that maintenance should be provided to the legitimate or illegitimate child both. However, in this case, Supreme Court and many other courts have stated and talked about the legitimacy that arises when a child is born out of a live-in relationship, which is very necessary when we claim for the right of property. Because under Hindu Marriage Act, the right of property is only entitled to the class 1 heirs of the.
Yes.
In case of Talsa versus Durgatya, it was clearly stated that the legal status to the children born out of live-in relationship should be provided under two conditions. If the husband and wife have resided together for a considerably long time, in this case for more than 3 years, and also they have cohabited under the same roof. My second case to rely on this is Dimple Gupta versus Rajiv Gupta, where the court has stated that children born out of live-in relationships are legitimate and have the same rights as that of case in from the valid marriage. The third case that I've relied on is SP Balasubram versus Shrutava, where it is stated that if a man and a woman are living under the same roof for years, then it would be presumed that under Section 114 of Evidence Act, they live as husband and wife, and children that are born out of this relationship are not illegitimate. Again, in Vidyavati versus Sukranbai, the court has clearly stated that a court has granted the right of inheritance to the children that are born out of live-in relationship and granted him legal status. In this case, Mitansh is legally a heir of Naveen, and hence he is entitled to maintenance as well as his right in property. May I proceed with the third issue?
So, all right, under the Domestic Violence Act, can he claim the right to property? Maintenance,
Not
yes.
under the Domestic Violence
So
Act.
your
But
application before the judicial magistrate was an application under the Domestic Violence Act.
that was for the maintenance. When we come to the Right of Property Act, we are claiming that he was a legitimate child, which is again proven in the
When are you
125th
claiming that
CR.
right? Before whom are you claiming the right of inheritance?
The court, the High
Which court? Which court?
High
The
Court, because
magistrate.
no, the magistrate court was just limited to providing the maintenance, and then we further claim that after maintenance also he has a right to claim for property which is under this court.
So before which court did you claim that right to property?
High Court.
All right, but directly before the High Court,
Because
you're challenging
yes,
the orders
because
of
no,
yes.
yes, under the magistrate court it was limited to providing of maintenance. After providing for maintenance, once we are proving that he is a legitimate heir, we are demanding for a right of property.
All right. Okay.
May I proceed with the third issue?
Yes, you proceed. Yes.
My third issue is whether Anvita is entitled to the share of profit arising out of the activities of drama school. Now, the drama school was a joint venture that was started by both Anvita and Navi. A joint venture is an association which is started by both the parties, may it be individual or a corporate. Now, the basic element for a joint venture is share of property and loss. Now, when it comes to joint venture, a contract has to be formed. The contract may be oral or it can be expressed. Now, in this case, it was an implied contract since both the parties have been running this business since 3 years, and it has been running very smoothly. One of the major elements that for joint venture is joint ownership, and implied or expressed agreement. All the three have been completed by both the parties, since it is a joint ownership as it was started by both the parties, and also it has an equal amount of share by both the parties. Both of them have invested equally into it. It is a joint operation because it has been running smoothly for past 3 years, and now it has arose questions of joint and implied agreement because both of them through their behavior have implied that they would be sharing their profits till now, which they have been sharing. However, Naveen after 3 years has stopped sharing the profits that arose from the drama business. Also, under the Partnership Act, Section 4 of Partnership Act, partners are those who share the profits of a business. And under Section 13B of the Partnership Act, when we talk about the share of profits, even though it has not been expressly written in the contract of how much share it has to be provided, it is always held that the share of profits has to be equal. The cases that I have relied for the same is Mancharam versus Tejban, Durga Prasad Rajaram Aditya versus Commissioner of Income Tax, and income tax officers versus Gimran and Company. In all the three cases, it has been clearly stated by the Supreme Court that the share of profits by partners has always supposed to be equal. If the lordships permit, may I just proceed with the prayer for 30 seconds?
Yes.
In the light of facts presented, issues raised, arguments advanced, and authorities cited, the council, on behalf of the appellant, humbly prays before this honorable court that it may be pleased to declare by judgment that Anvita and her child are entitled to maintenance of rupees 80,000 and it should be provided by them to Naveen. Second, to declare by judgment that Naveen is liable to provide profit with interest of 10% per annum to Anvita arising out of the drama business. And third, to partly uphold the judgment of Magistrate Court and District Session Court and or pass any other order, direction, or relief that this honorable court may deem fit in the interest of justice, equity, and good conscience. For this act of kindness of your lordship, the appellant as duty bound shall ever pray. Much obliged.
Much obliged, your lordships.
Much obliged, your lordships. I bow down to the court. Hope I am audible, your lordships.
Yes.
The respectful submission is on behalf of respondents in the case of Avanita versus Naveen in front of the Honorable High Court by Team 5. The lordships council would address this honorable court with the due permission as your lordships. In the foremost apprehensions of the matter, your lordships, the council seeks permission to put forth the contentions taken by the respondents, your lordships, with the due permission.
Yes.
Thank you so much, your lordships. Your lordships, respondents have taken two substantial issues. First issue deals with the profitability and the grammar school, and second issue deals with the constitutional validity of live-in relationship, which will be dealt by the co-counsel, your lordships. With your due permission, your lordships, council would seek permission to proceed with the first issue.
Yes.
Thank you so much, your lordships. As far as first issue is concerned, your lordships, it was in joint ownership, and joint ownership is mentioned in section 4 of the Indian Partnership Act, your lordships. One of the essentials talks about the joint ownership, hence it is proved that it was in joint ownership. Further, your lordships, section in every joint ownership, it is mentioned in the law in the Indian Partnership Act. It must be registered under section 59 of the Indian Partnership Act, your lordships. Section 69 is about the effects of non-registration, your lordships. In the case of Shriram Finance Corporation versus Yashir Khan and others, and also in the case of Seth Lokayuktas versus M.R. Arvind Jones and others, your lordships. It is clearly mentioned by the Supreme Court about the scope and interpretation of section 69 that every partnership firm must be registered. If it is not registered, then there is no remedy to approach the court about the issues of the partnership, your lordships. In this particular matter, your lordships, there was no registration of partnership. Even petitioners, as mentioned in the particular humble submission of the petitioners in the issue number 3, that in the section 4, it is clearly mentioned that there must be any contract. Even though there is no contract, your lordship, they are demanding for the profitability, your lordship. And if it is a partnership, then profits and losses and liabilities go hand in hand, your lordships. In the year 2014, it was a financial crisis, so they are also entitled for the liabilities, your lordships. Furthermore, taking contentions which they have taken, your lordships, in the humble submission of petitioners, in page number 17, they have tried to compare and take the support of section 125 of CRPC and section 2F of protection for women from the domestic violence in the of Act 2005. It is clearly mentioned in that particular submission, your lordships, about in the case Badri Prasad versus Deputy Director of Consolidation, your lordships. In that particular case, it was mentioned that by the Supreme Court that the live-in relationship partner has the equal rights of marriage. But in that particular case, it was 50 years of long live-in relationship, your lordships. And in this particular matter, it is the only question of 3 years, your lordship, and hence they are not entitled. It is clearly mentioned in the Indira Sharma versus VKV Sharma, your lordships, that the criteria and guidelines about the equal status of marriage to the live-in relationship couple, your lordships. It is clearly mentioned that there must be a reasonable time period, and hence here only 3 years is cannot be considered as a reasonable time period in accordance with the respondents' contentions, your lordships. Further, moving to the maintenance issue, your lordships, they are demanding for the maintenance. It is clearly mentioned the respondents have relied upon the judgments of Privy Council as well as the Superior Court of California, lordships. As we compare the Society of India as well as the United States, your lordships, live-in relationship there is a vast difference, and there is no meaning of applicability of that all judgments in this particular submission, your lordships. and hence it is totally exercise of floxinoxyhalipilification, your lordships. Further, moving towards the issue 2, sub issue 2 of the petitioners, they have demanded for the custody of the they have demanded for the maintenance and inheritance of child, your lordships. It is clearly mentioned in the Supreme Court cases, and further to the to bring to the notice of this honorable court, your lordships, respondents has filed an application in the family court for the custody of child, your lordships, and family court has accepted the custody, and this petitioners has filed a stay order on the family court's application for the custody, which clearly states that it is that they have the malified intention of stopping from the custody of child. Furthermore, there is no meaning of discussing that point, because there is no it is totally different subject matters as far as custody of child is concerned, your lordship. Further, moving towards the maintenance issue, your lordships, the contentions taken by the petitioners is actually, it seems that during the course of interpretation of the judgments done by submitted in the front of the honorable court by the learned petitioners, your lordships, they failed to understand the essence and the nature of the judicial interpretation of the judgments they have taken, your lordships. It also seems that the judicial interpretation of the judgments which they have taken, your lordships, is totally defenestrating, your lordships. Further, it is also contended by the petitioners about the jurisdiction, your lordships, but there is no question of jurisdiction as far as we are on the stage of final hearing in the front of High Court, your lordships. Further, your lordships, counsel will deal. My co-counsel will deal with the constitutional issue and constitutional validity of the living relationship, your lordships, as far as the particular matter is concerned, your lordships. I hand over to my co-counsel, your lordship, for the second issue. Much obliged.
Your lordships, I hope I am audible.
Yes.
Yes. The council would proceed with the second issue, which is, with changing times, there is an extensible need to set a precedent to eradicate the ambiguity in the entire concept of live-in relationship, your lordship. Bringing into light the judgment of the Supreme Court, live-in relationship is considered as a part and parcel of the right to life, your lordships, under Article 21 of the Indian Constitution, your lordships. When we take into consideration the concept of live-in relationship, it is also to be noted that it has no strings attached to a statutory law. In India, when we say that we need to focus on the rights and duties of the partners in a live-in relationship, we do not have a statutory written law, or we are still into ambiguity when we consider aspects of live-in relationship as to maintenance, inheritance, alimony, or also when we say that the status of a wife and also the male partner in the live-in relationship, your lordships. In the report of 2008 given by the Malimat committee, they have stated that the interpretation of the word wife shall be done as as a woman living with a man as his wife for a reasonably long period of time, your lordships. It is important to note that the reasonably long period of time is a phrase which can be interpreted on the aspect of any particular case, your lordship. It differs from one case to another, and it cannot have a particular time frame, your lordship, because it has never been stated by any of the judgments that of the High Court. Your lordship, it is also taken by the worthy petitioners in this particular matter. The case cited by them in their written submission is Badri Prasad versus Deputy Director of Consolidation. It states that the living relationship is given the status of a marriage for a relationship for a term of 50 years, your lordship. But this particular case deals with a living relationship of only 3 years of living relationship, your lordship. When we see that there is no time bar given by the law, we need an extensible constitutional validation for the same, your lordships. Even we can focus on the aspect which is herein given as that till date, neither an High Court nor the Supreme Court has given any written evidence or any specific time exclusive bar to judge the phrase that is the long period of cohabitation, your lordships. Furthermore, coming to the issue that they have taken, citing the judgment of D. Velusimi versus Panchayatamal, they have considered that palimony shall be given in this particular living relationship, your lordship. The council would counter it that the fourth point in this particular judgment that is cited by the court is given that they should have deliberately lived together for a noteworthy time frame, your lordship. Again, the question is that what is a noteworthy time frame, which is never even given in the law. Your lordship, in Indra Sharma versus BKV Sharma, it is also stated that the court requested the Parliament to get appropriate changes to the Protection of Women under Domestic Violence Act in order to secure the partners in a living relationship, because there is no relationship, it is similar to a nature of marriage, your lordships. Quoting Mr. H.R. Bharadwaj, the Honorable Union Law Minister in 2008, the right time has come that efforts should have been made to enact a law having clear provisions with regard to the time span required to give status to the relationship, registration, and rights of the parties, your lordships. The respondents have never denied the maintenance to the son Mitansh, your lordships, but the maintenance cannot be granted under the sections CRPC section 125, your lordships. Your lordships, dealing with another case in Madan Mohan Singh versus Rajnikant, the court has held that living relationship, if continued for a long period of time, it cannot be termed as a walk-in and walk-out relationship, your lordships. The respondents have never worthily walked out of the living relationship. It was the petitioner who left the apartment residence of the respondents, your lordships. The court is in the favor of treating the long-term living relationships as marriage rather than giving them a concept of living relationship, your lordships. It is to be focused that when we deal with the concept of living relationship, all the issues related to this concept have no statutory law formed, and conditions of cohabitation, protecting rights of the partners, right of the children, and inheritance right of the partners. Also, the grounds of separations are into ambiguity, your lordships. There are so many judgments that have been cited by the court, your lordships, and the respondents humbly pray that if there is no substantive law, then the interpretation of the concept of living relationship is always into a futile nature and is ambiguous in the particular matter, your lordships. The law is considering the concept of living relationship as a concept which is not immoral, your lordships. So the council would now move on with the prayer.
Why do you say that the child is not entitled to maintenance under section 125?
Your
You
lordship,
said that the child is not entitled to maintenance under section 125. Why do you say so?
ma'am, your lordship, because when we say that maintenance to the child is to be given, the issue will be dealt with the family court. In first place, section 125 of
Just a
CRPC
moment. In the family court, the issue is with regard to custody of the child.
Yes.
Whereas the application made before the learned judicial magistrate is for maintenance. Now,
yes,
can she not claim maintenance for the child before the learned judicial magistrate under the Domestic Violence Act or under section 125?
your lordship, I would answer this question as in first place, the petitioners are seeking maintenance under the Domestic Violence Act, and
Yes.
also according to the CRPC, the section 125 only talks about the maintenance of the term wife, and herein the
No, no.
petitioner is not
We
the
are talking
legally
about the child. You said the child is not entitled. So the
no,
query is only
the
restricted
lordship,
to
the
the child.
maintenance of the child and the running, like the adequate standard of living for the child would be definitely provided by the respondent in the first place, but the maintenance for the wife shall not be provided to them.
Okay.
The council seeks permission to proceed with the prayer.
Yes.
Yes.
Yeah, proceed.
In the most humble manner, the honorable court may be pleased to graciously grant to state that the issue pertaining to the share of profit is not maintainable in the court of law. Secondly, set a breakthrough for such ambiguous matters of relationship, and or grant any other relief that the honorable court may be pleased to grant in uplifting the principles of justice, equity, and good conscience, all of which is most respectfully prayed before the honorable court. The council rests the submission.
Yes. Rebuttal.
Ma'am, may I proceed with the rebuttal?
Yes, yes.
Your Lordship.
Yes.
Your
Proceed.
Lordship, as the respondents have stated that the partners can't file case against each other in an unregistered partnership form. So I would like to state the two cases. First case is of Shiodat versus Pushiram. In that suit, it was stated that it was against one partner against another partner, and the facts of the case were similar to the case in hand. And the court stated that the suit is competent as the partners inter se can file case against each other in an unregistered form, but
Yes.
the firm can't be sued or the firm can't sue. but the partners inter se can sue each other for profit sharing issues and settling accounts. And in the case of dissolution, also the same was found in the case of Shiba Mal versus Gulab Rai. The same has been stated by the Honorable Court that the partners inter se in an unregistered firm can file case against each other for these three issues. Also, I would like to state that the second issue which I would like to say, that the respondents have in their submissions mentioned that have mentioned that the respondent has financial crisis, and so how can he give maintenance to the petitioner. So I would like to state that beg, borrow or steal, the same was being quoted by Justice H.S. Madan of Punjab and Haryana High Court. He quoted, I would like to read, that the first and foremost duty of the husband is to maintain wife and child, and for that he may beg, borrow or steal. uh, Here I would like to conclude my submissions, Your Lordship. Thank you. Much obliged.
Lordship's counsel seeks permission for the sir rebuttal.
Yes.
Your Lordships, as mentioned by the petitioners, London petitioners, about the profitability and Section 69 of the Indian Partnership Act, I would like to quote the Patna High Court, who have explained the approach of Section 69. And I quote, subsequent registration cannot cure the intense deficit. A plaint filed by an unregistered firm is in fact no plaint at all, Your Lordships.
Just a moment. See,
Because
just a moment, Mr. Just a moment. Her answer was not that they got subsequently registered. She said that as a firm, they cannot approach the court because the firm is legally is not registered. Her answer was that a partner can still approach the court claiming the share against another partner, while a firm cannot approach a partner. That was her answer. So she is not claiming anything with regard to registration.
Lordship.
Yes.
Firm can definitely approach the court of law, Your Lordship, but there must be a written contract also, Your Lordships. There are two ways of approaching the court of law, Your Lordships. First is Section 16. Under Section 16, they cannot approach the court. And another essential, if they can approach the court by individuals, Your Lordships, on the basis of the contract. But there was not even a written contract, Your Lordships, about the partnership firm, Your Lordships. And hence respondents seeks that there is no, and at the time of your financial crisis, Your Lordships, with the malafide intention, petitioners left the home and living relationship, Your Lordship, with the intention of not paying and participating in the liabilities of the drama school, Your Lordships. And respondents had solely participated in the drama school and completely paid all the liabilities of the drama school, Your Lordships. And after not participating in the liabilities, respondents pray this honorable court for not directing any order to the petitioners for the granting any profit out of the grammar school, Your Lordships. Furthermore, Your Lordships, I would like to address this honorable court one mistake from the respondents, Your Lordships. The custody thing which Your Lordships addressed, I would like to put forth in the front of honorable court that the custody application is filed in the honorable family court, and hence the custody application is pending in the honorable family court. There is no meaning of arguing and discussing upon the matter of maintenance and inheritance, Your Lordships, because we must wait for the procedures to go on in the family court, and then it is the time for the discussion in the custody matter, Your Lordships. And hence we are saying that we are not denying that the custody cannot be granted to the child under Section 125. But what if the custody is granted to the respondents, ma'am? Then there is no question of application of the maintenance and inheritance, Your Lordships. That is the only humble submission to the Lordships. It was a pleasure arguing in front of the Lordships. Thank you so much.
I request A2 and R2 to leave the studio.
Much obliged.
Yes.
Lordship may permit, can I join A3 and R3?
Yes.
Okay.
Am I audible, Your Lordship?
Yes.
So the council is from TM6 orally.
Yes.
The council would like to address bench as your lordship.
Yes.
Much obliged. If your lordship is well aware of the facts, may I proceed with the issues?
Yes, Your Lordship.
Yes.
Council has divided the arguments into 5. And 2 will be dealt by me and other 2 will be dealt by my co-counsel. So our first issue is that whether the Honorable High Court of Gujarat is jurisdiction to entertain and decide the approach petition together, and what is the scope of interference in such petition under writ jurisdiction. So yes, the Gujarat High Court has jurisdiction to club petition together, as it was held in the various cases like Adnan Billah Mullah versus State of Maharashtra, also in the case of SBI versus Ranjan Chemicals Limited, also in the case of Champaben Ranchod by Gamit versus State of Gujarat. The Honorable High Court has club petition which is of similar nature. So in our case also Gujarat High Court does have jurisdiction to club petition together as it is of a similar nature. And when we talk about the scope of interference, then we have to talk about domestic violence act. As the aim of bringing domestic violence act was that they have to the legislature wanted to provide remedies reliefs to the women. So the main aim beside this act was to provide relief to the women. So as we refer section 29 of the Domestic Violence Act, it doesn't provide appeal after the session court. So a court can so a petitioner can approach High Court for further relief. So we have approached under 226 and 227 under to the High Court because there was no further appeal under Domestic Violence Act. And also various cases like Sabita Mark Burks versus Mark Leon Burks, Aruna versus Om Prakash Bar Mohit versus State of Maharashtra, the court has admitted writ petition under Article 226 and 227 regarding the matter of domestic violence.
Yes.
If your lordship permits, may I proceed with my second issue?
Proceed.
Yes.
So my second issue is related to the can any order be passed by family court in the respect of the custody of minor Mitans at this stage of proceeding with the custody application pending before the Honorable High Court on various issues. So it is humbly submitted before this Honorable High Court that the family court should not pass any judgment related to the custody of Mitans because the matter is sub judice in the High Court. Also, if we go by the concept of jurisprudence of family court, it deals with that a family court should give a judgment which is healthy, which healthily solve family disputes. And if we go by this definition, the most healthy way to solve family dispute would be to take care of the interests of the child. And also in the various cases, the court has said that the welfare of child is being paramount consideration while granting the custody of a child. It was held in the case of Sridevi versus Mani, also in the case of Shelo Hati versus Somnath Das. Also, if we go by the case of Gayatri Bajaj versus Jiten Khalla, it was held that a desire of child should be considered and should be coupled with the upbringing of child. That how child would be upbringing would be held if custody of a child is given to a particular parent. So the best interest and welfare of child can only be decided by when the petition which is pending before the Honorable High Court regarding abuse and maintenance is educated and disposed of. As it won't be in the welfare of a child to give the custody of a Mitans to Naveen because he has started drinking alcohol and he also started maintaining distance with Mitans when Anvita returned from Arbuda. Also, if a family court pass a judgment regarding the custody of a child, though the matter is pending before the High Court, it would amount to a vicious cycles because if judgment come in our favor regarding abuse and maintenance, and the family court during that time pass the custody of a child in the favor of Naveen, then it won't be in the interest and welfare of the child. Also, it is further submitted before the Honorable Court is that matter is pending before the High Court and family court is a subordinate court. So they should not interfere in this matter because it is pending before the Honorable High Court. Because in the cases of Vishwanath P. Maheshwar versus Suryavanshi, Balrup Thakur and others, the Bombay High Court stated when the matter is sub judice in the High Court, though there was no clear stay by the Bombay High Court, family court should not have proceed with the matter. And also, same in the case of Anshu Dutt versus Anisha Dutt, it was held that when the matter is sub judice in the High Court, family court should refrain from passing any order. If your lordship permits, may I proceed with my third issue?
Yes. Yes.
whether Anvita is entitled to share of profit arising out of the activities of Dharma school? If yes, can Naveen be directed by the court to the patient? Yes, Anvita is entitled to get profit arising out of Dharma school, as they both started drama school uh, jointly, and it was held that it was a joint venture. Also, according to the section of 26B of Companies Act, says that the joint venture means a joint arrangement where the parties that have joint control over the arrangements have rights to the net assets of the arrangement. And also in the equity.
Just a query, I'm just interrupting. Can you point out the provisions of the Domestic Violence Act under which you are claiming a share in the joint venture?
No, we are not claiming under Domestic Violence Act.
Okay, then under which act are you claiming and before whom are you claiming it?
So,
because your application was before the learned judicial magistrate under the Domestic Violence Act, and he has the power to grant you only relief under that act. So when you are claiming share in a property, before which court are you seeking it and under which provision are you seeking it?
The council would like to draw attention of your ladyship on page number 20 of my memory. In the case of Lalji Bhai Prakash Bhai Savliya versus State of Gujarat, the Honorable Gujarat High Court extended the ambit of maintenance by including the profit sharing in its domain. Because here the profit sharing was very important, because she had no money, because they only had one drama school for their livelihood. She was not able to maintain herself, because she was also not getting profit out of that joint venture.
All right.
May I proceed?
Yes.
So the equity-based joint venture is basically depends on the profit and loss sharing concept. And also in the case of Woosley versus petrol pump production management, the court said that the 5 elements above the mentioned need not to be present in a joint venture. Simply a joint ownership, joint operation, and express or implied agreement should be present in a joint venture, which was in our case. Also, if we go by the case of Leon Corp versus PCB Association, it was held the elements of a joint venture is similar kind of a partnership. And if we go by the definition of 13B of Indian Partnership Act, which says that the partners are entitled to share profit equally in the profits earned. If your ladyship permit, may I conclude my argument in 1 minute?
Yes.
Much obliged. And shall contribute equally to the losses sustained by the firm. Also, in the case of Mansha Ram versus Tej Ram, it was held that when there is no clear proportionate of distribution of profit, then it should be distributed equally, and the liability lies on the person who is claiming that a profit should not be divided equally to prove that it should not be divided equally. As also we got a judgment in our favor regarding this profit sharing with the compensation of 10% from the magistrate. Also, Anvita is not getting a maintenance from Miss Naveen, so she should get maintenance also, and she should also get profit after sales, so she can run her house. As I have already cited the case of Lalji Bhai Prakash Savaliya versus State of Gujarat, in which Gujarat High Court included the profit sharing in the ambit of maintenance also.
Right.
Much obliged.
Yes.
Lordship, with your permission, I would like to proceed with issue number 4.
Yes.
The petitioner seeks to contend that the relationship in the nature of marriage was indeed based on the false promise of marriage in the present case. Your Lordship, I must draw your attention to clauses 2, 3, 4, 5, and 6 of section 375 of the IPC, where consent has been given separate importance, and it is said the consent of woman is essential for the physical relationship to be legitimate and not rape. Your Lordships, further, section 90 of the IPC also defines consent separately, and it includes the fact that consent may be vitiated when it is given under fear or misconception of fact. Your Lordships, the courts have further expanded the requirements for valid consent by reading into it that the person taking consent for sexual intercourse on the pretext of false marriage would amount to rape. It is important here to consider that such cases are those to make a distinction here. We can make the note that where the relationship has been given only on the pretext of on the false promise of marriage, and where such promise was not made, consent would not have been given. Lordship, the same has been observed in Kaini Rajan versus State of Kerala, where the court observes that whether there was consent or not is to be ascertained only on the careful study of all the relevant circumstances. I would like to highlight the fact that in every case, there must be due consideration given to the context of the case. In state of UP versus Naushad, the Supreme Court again convicted the appellant for rape when the mutual consent for sexual relations was obtained by giving false promise of marriage, which was later never carried out, and even after the prosecutrix became pregnant. Your Lordships, further, I would like to contend that in the present case, this was a clear-cut example of consent to physical relationships on the false promise of marriage. Here I would like to highlight the fact that in the fact sheet itself it is mentioned that after falling in love they had a mutual agreement to get married, and after which the petitioner and the respondent approached their respective parents, after which the petitioner's parents raised objections. So here there is an obvious explicit mention of a mutual agreement to marry each other.
See, just a
I would
moment.
like
I'm interrupting for a moment. In
Yes,
the
it
facts,
is.
it is stated that they intended to get married, and the father objected because the respondent was a married man. So
Yes,
obviously, they could not have got married at that point of time. When they
yes, Your
entered
Lordship.
into the live-in relationship, it was not possible for them to get married.
Yes, Your Lordship. But
So
the
that
but I would
marriage
like
could
to
have come subsequently after he got divorced. Till
Yes,
then, there
Your
was no
Lordship.
question of marriage. So when she
Yes, Your
entered
Lordship.
into the relationship, there was no question of getting married. There was only an intention to get married.
Yes, Your Lordship. But I would like to take up this issue further when I reach my
Yes.
issue 5, which I go into
Okay.
this in
Okay.
depth. In the
Okay.
case of Uday versus State of Karnataka, the court observes that there is no straitjacket formula for determining whether consent is given by the prosecutrix to the sexual intercourse voluntarily or whether it is given under a misconception of fact. The court must, in each case, consider the evidence before it surrounding the circumstances before reaching a conclusion, because each case has its own peculiar facts and may have a bearing on the question whether the consent was voluntary or was given under a misconception of fact. Observing the same, I would like to highlight the facts and circumstances that have preceded before this present case has come before the court. First, after working together for more than 1 year in the media firm, the parties fell in love with each other. And after falling in love, the parties continued to work with each other and maintain an intimate relationship for another 2 years. They both decided to mutually get married only after this period. The respondent approached the parents of the petitioner, which is a clear indication of the intention of for a relationship to be more than that of a mere fling and to be that in the nature of marriage. Third, the respondent had filed for mutual divorce under Section 13B of the Hindu Marriage Act, only subsequent to which the petitioner agreed to get in a mutual cohabitation with him in a separate city. Fourth, the respondent, along with the petitioner, left his job and moved to a separate city altogether in the city of Nagarabad. Fifth, the respondent pooled money from his life savings along with the petitioner for the joint venture of drama school. And sixth, the respondent indulged in physical relationship, and through which they also had the issue of Mitanj. I would like to highlight the fact that the announcement of the pregnancy was done in February 2013, and it is never mentioned that the respondent ever objected to the pregnancy or suggested abortion or ever threatened to walk out of the relationship. It is clear that he was happy with the announcement of the pregnancy, and this considered together is substantial reason for the presumption of by the petitioner that there is a future promise of marriage. In Yedla Srinivasa Rao versus State of Andhra Pradesh, the court upheld the conviction of the accused where repeated sexual relations were made by the accused with the victim, where the victim obliged only due to the repeated reassurances that he would marry her at a later stage. Your Lordships, I would also like to draw your attention to Section 114 of the Evidence Act, where the court is explicitly given permission to presume certain facts. To presume certain facts where inferences can be made. Further, no, I would like to contend whether the knowledge of the previous marriage should affect the current status of the current living relationship. Well, also, I would like to say that the petitioner in the current case is a lay woman. She has no knowledge about the technicalities or the technical issues of law. She only agreed to get in a mutual cohabitation after the petitioner, after the respondent got filed for mutual divorce under Section 13B, and this clearly shows that and this was after they had been in a relationship for 3 years. This clearly shows that she has displayed all the reasonable and due care on her part. um, Further, I would like to move on to my issue number 5, if your lordship would allow me further 2 minutes just to complete. um, in whether Anvita is entitled to a claim of maintenance. Your Lordships, in Indra Sharma versus VKV Sharma, the court observed that the American jurisprudence, where the legislature is always reluctant to go forth with a explicit legislation that allows for that protects women under that are not married, but it is also the court also says that it is a duty of the courts to accept to protect women in such relationships. Such relationships, it may be noted, may endure for a long time and can result in a pattern of dependency and vulnerability. An increasing number of such relationships call for adequate and effective protection. Your Lordships, in the case of Andhra Handinge Dinohemi versus Vijayatunge Blahemi, the Privy Council, as early as 1927, first granted recognition that a relationship in the nature of marriage does exist, where the court observed that the law will presume, unless the opposite be obviously demonstrated, that they were living respectively in a result of a legitimate marriage and not in the condition of a concubinage. Your Lordships, I would like to draw a brief history of the nature of living relationships. For the first time, the Marinath Committee in 2000 recommended when
So you'll have
recommending
to cut short your arguments and come directly to the point.
Okay,
You're
Your
running
Lordship,
out of
I'll do
time.
that.
Yes.
So sorry, Your Lordship. I'll come to my main arguments. In section 125 of the CRPC talks about maintenance to certain dependents of a man. Your Lordship, it explicitly mentions wife, but has further been expanded by the courts at various instances to include women who are in the relationship of marriage. One of these cases being Chinmaya versus Virendra Singh Kushwa. Lordships, further, in Madan Mohan versus Rajnikant, the court concluded that a long-term living relationship cannot be called a walk-in and walk-out relationship, and there is a presumption of marriage between the parties, and such presumption can only be rebutted by leading an unimpeachable evidence. Further, in D. Velluswamy versus D. Pattachaimal, the court highlighted that the women who are entitled in a living relationship who are entitled to maintenance have the same conditions as that of a common law marriage. These conditions being that the couple must hold themselves out to society being akin to that of spouses, they must be of a legal age to marry, they must otherwise be qualified to enter into a legal marriage, and that they must voluntarily cohabit and hold themselves out to society as being akin to spouses. Your Lordship,
So
as you had raised,
you just read that they must be qualified
yes,
to be in a legal marriage. Now
yes.
here, admittedly, the other side was married. Was he qualified to enter into a legal marriage?
Yes, Your Lordship. That's what I was coming to. That the legislation that the president clearly states that they must be otherwise qualified to marry. But here, in the present case, the respondent was judicially separated. Your Lordship, this is a case where the law is not clear. The judgment clearly states that they must otherwise be qualified to marry, but it also doesn't state that a judicially separate person is not qualified to
It
be
doesn't
a
need to be
married
stated. See,
person.
a person is not a married person till he is divorced. Judicial
Yes, Your
separation
Lordship.
does not sever the marriage.
Your
So,
Lordship, I was
unless he
yes.
is divorced, he is not capable of getting married.
Yes, Your Lordship, but in the case of GV Chitti Abai, the court
Yes.
had observed that the 6 month waiting period under a mutual divorce is not that of a mandatory nature and is that of a directory nature. The facts in the case are not clear. It has not indicated that it has used the word legally separated, not judicially separation. So there, in this case, we would be drawing an assumption that the court has that they have not gotten a decree for divorce but are living in a judicially separated state. Your Lordship, further, I would just like to add just 30 more seconds to give seven conditions that were laid down in VKV Sharma. There were seven conditions laid down in VKV Sharma where the relationship can be held to be a relationship in the nature of marriage. First, duration period of the relationship. Here, in the present case, both the parties have been living together for 3 years amicably and have had a relationship for an even longer period. Shared household. Both the parties have been living in the shared household for 3 years. Pooling of resources. The court says supporting each other or any of them financially sharing bank accounts, acquiring immovable property in the joint names, or long-term business investments are pooling of resources and financial arrangements. Here, their joint establishment is a clear satisfaction in this condition. Sexual relationship. Both the parties have had mutual and amicable sexual relationships, and through which the issue of Mitanch has been born. Children. The court specifically states having of children is a strong indication as to the nature of relationship being that of marriage. Here, the respondent never objected to the child, and it is clear that he's performed all the responsibilities and duties of a father up till 2014 when he when Anvita had moved out. Further, in the case of Abhijit Bikashet
You
versus
can't continue with submissions like this. I mean, more
so
judgment and
sorry, Your
judgment.
Worship.
You are
I'm
already out
just
of
ending.
time. Yes.
This is my final judgment. I would just like to contend that the applicants contend that even disregarding the above made judicial observations and provisions, the applicant would still be entitled to maintenance regardless, as the same was has been enunciated in Abhijit Bikashet versus State of Maharashtra, that a woman does not need to prove her marriage is entitled to prove to be married to be entitled to maintenance. Well, Lordships, further with your permission, I would like to give my co-counsel the to come forward with the prayers.
If your lordship permit, may I proceed with the prayer?
Yes.
If your lordship permits, may I proceed with prayer?
Yes.
Wherefore, in the lights of the issues raised, argument advanced, and authorities cited, the counsel for the petitioners humbly prays that the Honorable Court be pleased to adjudge, hold, and declare that the court may give the judgment directing the respondent to pay the share of profit arising out of the drama school, along with the interest thereby upholding the judgment of the subordinate court. The court may give the judgment in the favor of the inheritance of the property by Mitansh. That the court may give the judgment directing the payment of compensation for the mental abuse which the petitioner was subject to. That there must be payment of maintenance by the respondent to the petitioner by virtue of both Domestic Violence Act and Section 125 of CRPC, and or pass any other relief that the Honorable Court may be pleased to grant in the interest of justice, equity, and good conscience.
Yes.
Lordship, am I audible?
Yes.
Yes, yes.
Lordship, this is TM7 appearing for the respondents. This is oralist 1. I'll be dealing with issues number 1 and 2, whereas my co-counsel will be dealing with issues number 3 and 4. The petitioner has invoked the jurisdiction of this Honorable High Court by filing the criminal writ petition under the DV Act and by filing another civil writ petition, which has the cause to adjourn the proceedings in the family court. If the lordships are well versed with the facts and may I proceed with the issues?
Yes.
Lordship, the first issue is of the jurisdiction and of the scope of interference of the High Court. Now, firstly, the Council would like to draw your attention to page number 13 of the written submissions of the Council. When it is in the fact sheet, it is clearly stated that an application to adjourn the proceedings before the family court was made by the petitioner, and that application was rejected by the Honorable Family Court, and through which the petitioner is here in the High Court because the application of adjournment was rejected. Now, the scope of criminal writ petition and the civil writ petition is absolutely different. They are totally different in nature, and the causes are also different because the civil writ petition does not include the issue of the custody of the minor child. Further, the council would like to submit that the Honorable High Court may hear the petitions, the criminal writ petitions together, as it is a common practice of the court to decide the petitions arising out of the same judgment together. Further, in the light of this, the sub issue, which is whether the High Court has the scope to interfere in the civil writ petition, it is humbly submitted that under Section 19 of the Family Courts Act, it is clearly mentioned that no appeal shall lie from an interlocutory order which is given by a family court. The same was mentioned in the case Rasik Kumar alias Rasik Kantilal Patel, wherein the court held that wherein an interlocutory order is passed by a family court, the appeal is not maintainable in the High Court. And in this case, Lordships, the matter of the adjournment of the proceedings is already pending before the family court. With your permission, the council would further like to move on to issue number 2.
Yes.
Oblige, your lordship. The issue number 2 is whether the sexual relationship between parties can be termed as sexual abuse. Now, firstly, in order to constitute sexual abuse, the consent should not be willfully given. Lordships, the consent here was very much willfully given. There are two facts which prove that the consent was willfully given. The first one being that the petitioner had the knowledge of the first marriage of the respondent. Secondly, the petitioner also knew that there was a strong opposition of marriage from the petitioner side of the family. Thus, she willfully gave her consent well knowingly knowing that these were the issues in the marriage. Now, in the light of this issue, Your Lordships, the section number 90 of the IPC is to be looked at. The section number 90 states that consent known to be given under fear or misconception. Now, if the case does not fall under section 90, if the consent is freely given, being fully aware of the consequences, and then the consent will not fall under the purview of section 90 of IPC Lordships. In the case of Uday versus State of Karnataka, it was clearly held that the if the woman has sufficient intelligence to understand the significance and moral quality of the act which she was consenting to, it will not fall under the purview of section 90. Further, Your Lordship, if the petitioner has freely, voluntarily, and consciously consented to having sexual intercourse with the respondent without any kind of force. Further, Your Lordship, if, when the issue of false promise is dealt with, when the petitioners urge that due to the false promise a sexual relationship was entered into, in the case of Pramod Suryaban Pawar versus the state of Maharashtra, it was held that the breach of promise cannot be said to be a false promise. In the case of Jayanti Rani Panda versus state of West Bengal, the Supreme Court held that if a full-grown girl consents to the act of sexual intercourse on a promise of marriage and continues to indulge in such activity until she becomes pregnant, it is an act of promiscuity on her part and it won't fall under section 90, Your Lordships. Lastly, the council would like to conclude by stating the case Maheshwar Tigga versus State of Jharkhand, wherein the Supreme Court held that a conscious and deliberated choice is distinct from an involuntary action or denial. My co-counsel would deal with the issues third and fourth. Much obliged, Your Lordship.
Yes.
Lordships, am I audible?
Yes.
Lordships, if there are no preliminary inquiries, the council seeks your humble permission to proceed with the issues.
Yes.
Much obliged, Your Lordship. Your Lordship, issue number 3 deals with whether the petitioner is entitled to claim maintenance for herself in the relationship which is not marriage. In order to claim maintenance under section 125 of CRPC, the petitioner has to fall within the definition of wife given under that section. Now, it may kindly be noted by this honorable court that the petitioner and the respondent are not legally married under any provision of law. Furthermore, Your Lordship, Section 125 of the CRPC defines wife as a woman who has been divorced by or has obtained a divorce from her husband and has not remarried. So, if a literal interpretation of this section is done, then the petitioner clearly does not fall within the ambit of the expression of wife. Your Lordship, keeping in mind the change in the society, a wider interpretation was adopted by the judiciary, but few essentials are important to be fulfilled in order to fall within the wider interpretation of expression of wife. Firstly, being that there should be no living spouse, and secondly, being that there should be no valid previous marriage. If your lordship may kindly turn to page 10 and look at para 4 of statement of facts, it clearly states that the respondent's current status is that he is already married and he is not yet divorced. No divorce decree has been passed. He is merely judicially legally separated. So therefore, his current status is that he is already married and is married in the Hindu marriage act. So he is not at all eligible to enter into a second marriage. Now, Lordship, it is submitted that in the case of Savita Ben Bhatia versus State of Gujarat, the Honorable Apex Court held that if a woman enters into a wedlock with a married man, then in no way she can be included within expression of wife under section 125 of CRPC. Furthermore, Your Lordship, in the case of Pyala versus Pyala, it was held that the scope of section 125 cannot be enlarged by introducing any artificial definition to include a second woman who is not legally married within the expression of wife if it is proved by the respondent husband that he is having a valid marriage and is previously married. Your Lordship, if the petitioners are claiming maintenance under Domestic Violence Act, it has to be established that the living relationship is falling within the purview of relationship in nature of marriage. Your Lordship, in the case of D. Veluswamy versus D. Pachema, the Supreme Court held that not all living relations fall within the purview of relationship in nature of marriage. Now, various essentials have been laid down in that judgment, and one of the essential being that they must be otherwise qualified to enter into legal marriage, including being unmarried. And your lordship clearly pointed out that the current status of respondent is married and is married in a Hindu marriage act. So he is not at all eligible to enter into. He is not at all qualified to enter into a legal marriage. Therefore, the conditions are not fulfilled. Furthermore, your lordship, in the case of VK Sharma versus in the case of VK Sharma versus Indra Sharma, it was held by the Supreme Court that all the essential laid down in the Vilu Swami case are necessary to be fulfilled in order for living relationship to fall within the purview of relationship in nature of marriage. Furthermore, your lordship, on the question of presumption of fact, in 2016, the Honorable Division Bench of the Supreme Court, in the case of Hiral Harsura versus Kusum Harsura, held that when the appellant woman is aware of the fact that the respondent is already married, then the general presumption that a man and woman who are living together are husband and wife will not at all apply. So clearly under that also, if the living relation was not falling within the purview of relationship in nature of marriage. Now, Lordship, may I proceed with my issue number 4?
Yes.
Lordship, the issue number 4 is whether the petitioner is entitled to share of profit arising out of activities of the drama school. Lordship, may kindly note that the respondent is as much dependent on the joint venture as the petitioner. Lordship, it may be noted that the petitioner and respondent were equally drawing their share of profit when the joint venture was making profit. Your Lordship, on page 10 in para 7 of Statement of Facts, it is clearly mentioned that both petitioner and respondent were facing financial crunch. This was because the joint venture was not earning profit and it was running into losses. And the partners who are sharing the profit together have to also bear the losses together. It cannot be said that on one hand the petitioner is asking for the profit, on the other hand she is willfully avoiding her duties towards the joint venture by not acting as a partner in the joint venture, by remaining unavailable for all these years, and she's not paying the liabilities arising out of her share of her share from the joint venture. Furthermore, your lordship, on one hand the petitioner is asking for their share of profit and willfully avoiding their duties in the joint venture. Secondly, your lordship, not only they are eligible to pay for the liabilities of the share arising out of the joint venture, but also proceedings of operation and mismanagement can be done against them. Your Lordship, I will conclude in 20 seconds with the prayer.
Yes.
Your Lordship, therefore, in the light of the issues raised, arguments advanced, reasons given, authorities cited, the Honorable Court may be graciously pleased to kindly order the petition to pay compensation, other monetary relief to the respondent for making defamatory allegations against him and causing a loss of reputation to the respondent, to kindly order the petition to pay her share of liabilities in the joint venture, to kindly dismiss the civil petition of adjournment of proceedings in the family court. Much obliged, Your Lordship. It was a pleasure arguing before this honorable.
Oblige, Your Lordship.
Your Lordships, with your permissions, I would like to start with
Yes.
the rebuttal to the side of the
Yes.
petitioner.
Yes,
It is
yes.
multiple times mentioned by the respondents that the relationship when the respondent got into a living relationship with the petitioner, he was already married. But I would like to draw your attention to the fact sheet here that the respondents are making a lot of assumptions because the fact sheet is silent about when the application for divorce was filed by the respondent. Thus, it is not thus we are not aware whether the 6-month period which has to be observed has elapsed or not. Further, as mentioned earlier, under various judgments, it has also been observed that when a application for mutual divorce has been submitted before the court under Section 13B, the court has observed that period of 6 months is not only mandatory but it can be also seen as directory and it may also be foregone entirely. Thus, there is an assumption here that the man was legally separated and was not already divorced by the already divorced in his previous marriage. Further, Your Lordships, when talking about financial losses, we would like to mention that the fact sheet mentions that the respondent was suffering, the joint venture was suffering financial losses, but it does not go into the quantum of losses. It is mentioned that 1,50,000 was the profit that they were deriving out of the venture earlier. But even a loss from that of 50,000 and thus earning 1 lakh would fall into the definition of financial losses. That means that the respondent is still earning, which is very clear by the fact that the respondent is indulging, is able to maintain himself, and is also indulging in other activities which are not required, such as having alcohol. Your Lordship, on the whereas the petitioner has to maintain not just herself but also their shared child, and she's not being able to derive any of the profits that are arising out of the joint venture. Thus, it is contended that the fact sheet is silent about both these facts, that there is a loss, there is a complete loss, and that the judicial separation period has not elapsed.
Your Lordship, may I proceed with sir rebuttal?
Yes.
Lordship.
Yes.
Yeah. Your Lordship, the petitioner clearly neglected the fact. If Your Lordship may kindly turn to page 10 and look at para 4 of the statement of facts of respondent member.
Yes.
Your Lordship, in it is clearly stated that in January 2010, the petitioner and the respondent started living together. And even though it is legally separated, the petition and it was during October 2010 that Naveen was legally separated from his wife. So in January 2010, the petitioner and respondent when lived in together, she was aware of the fact that he is not even legally separated with his wife.
Yes.
And in October 2010, it was only held down that he was legally separated from the wife from October 2010. Furthermore, Your Lordship, as far as the question of sharing of losses is given, it may be kindly noted that the petitioner are not at all saying that they will pay their share of losses. They are claiming they will they want their share of profit. But what about the question of paying their share of liabilities arising out of it? And thirdly, Your Lordship, as far as the maintenance of child is concerned, the respondent is already ready to maintain the child given the custody by the family court. So that matter is already sub judice before the family court, and let the family court decide. And if the petitioner is not able to maintain the child, it may kindly give it to the respondent, and we are happy to do so. And we
Is that a valid contention? Is that a valid contention? She is claiming maintenance under the Domestic Violence Act. You say you give me custody under the Family Courts Act, and I don't have to give maintenance. Then she is not
no,
able
Your
to maintain.
Lordship.
Yes.
Your Lordship, the petitioner is claiming that she is not able to maintain the
No,
child. So we
she's
have
claiming
already.
she's claiming maintenance to maintain herself and the child. She doesn't say I'm not able to look after the child if maintenance is given to me.
Your
So
Lordship,
you said that no.
the
So question of custody and maintenance cannot be mixed together. Can they be mixed together like this?
Your
Because
Lordship, it was the petition.
till you get custody by the family court, what happens about the maintenance of the child?
Your Lordship, it may be kindly noted that the respondent does not have any plan to maintain the child. But Your Lordship, the petitioner is in the garb of maintaining the child. She is asking for interim maintenance. We are readily happy to maintain the child, but it is the petitioner who is willfully in the garb of interim maintenance of the child. She is asking for all this maintenance, and all these baseless allegations are made against the respondent. Your Lordship,
Yes.
it was a pleasure writing before this court. May I leave?
Sure. Yes.
Much obliged, Your Lordships.
Much
A3 and
obliged, Your
R3
Lordship.
can A3 and R3 can leave the studio. Lordship may permit to join the next team.
Yes.
A4 and R4.
Yes. 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 You may start.
Ladyship, the appellants have been joining it.
All right, you are the respondents. Okay. Appellants are still
Indeed.
not there. Sorry.
May it please your lordships?
Yes.
On behalf of the
You're not audible properly. You're not audible.
Am I audible now?
Yes, yes.
Your lordships, if you discuss the fact, may you please proceed with the issues?
Yes.
Your lordships, the first, second, and the fifth issue shall be dealt by with me, and the fifth issue and the third and the fourth issue shall be dealt with by my co-counsel. Your lordship, we seek your permission to keep our submissions precise. Issue 1, whether the Honorable High Court of Gujarat has a jurisdiction in the said matter. The High Court of Gujarat very much has a jurisdiction under Article 226 and 227 of the Indian Constitution. Article 226 clearly states that when a person's legal or fundamental rights have been infringed, they may seek the court to seek remedy regarding the matter under 226. The High Court here has a discretionary power on the basis that the said matter has, even if the said matter's alternative remedies available. In the case of Mohammed and Yasir, the Apex Court had clearly said that even if there are alternative remedies available, a person may seek the court under 227 for speedy justice or for speedy trial if their fundamental rights or legal rights have been infringed. Secondly, your lordships, the High Court as a court of superintendents has a jurisdiction to examine any jurisdictional error apparent on the face of record or where the court has been totally misdirected. Normally, the High Court under Article 227 would not interfere in such matters where the subordinate courts have given their orders. But where there has been total misdirection by the lower court, the court under Article 227 has a jurisdiction to, exercise their jurisdiction, and it is justified in the interest of justice for us to approach the court under this matter. To conclude with this issue, your lordships, the court has been totally misdirected in the present case and has not considered the entire situation, justifying which justifies the interference of the court in the said matter under the writ petitions. May I proceed with issue 2?
Yes.
Thank you, Lordship. Issue 2 is whether the sexual relationship between the parties based on the consent of Ms. Anita through the promise of marriage be termed as sexual abuse or not, your lordship. To begin with, I would like to cite the case of S. Khushbu. The Apex Court has classified that a live-in relationship to be a domestic relationship, your lordships, under the Domestic Violence Act of 2005. The court here has said that live-in relationship is also considered under the ambit of Article 21 here. Domestic relationship has been established just on the fact that the two of them had been living together. That establishes their domestic relationships here. Here in this case, your lordship, please note that Anvita had been very keen on marrying Naveen, which is why she started living in with him together. And not only did she live in with him together, she also had a child with him, which also establishes the sexual relationship between them. All of this, your lordship, was obtained just on the basis on the promise of marriage, which was given by Naveen. So, your lordship, this can clearly prove this. Therefore, your lordship, the relationship was established on the promise of marriage, which later on was exploited by Naveen, can be classified as sexual abuse under considering the facts. Your lordship, it is also very important to note that the lower court has not considered the whole situation. Although the physical relationship was consented by Miss Anita, the consent was obtained on the promise of marriage. And that has not been fulfilled by Mr. Naveen, even after the impediment to marry her was gone after his divorce. Your lordship, please note that even after he divorced in 2010, they had time together till 2013, and he did not marry her in that time, which clearly establishes that he just wanted to exploit Miss Anita and claim sexual abuse. Thus, we can claim sexual abuse on this matter. Your lordships, while considering the matter, please also consider deciding the issue. Section 32(2) subsection of the DAV Act 2005 is also of great importance, and your lordship may please refer to that. Your lordship, this is all for the second issue. The third and the fourth issue shall be dealt with by my co-counsel.
Yes. Yes, you may start.
May it please your lordships.
Yes.
Lordship, coming to the third issue of maintenance, your lordships. Before going to that issue, your lordships, it is of great importance and it must be considered by the court that a broad and expansive interpretation should be given to the term wife under section 125 of the CRPC, your lordships, because such interpretation is just an application of principles enshrined in the preamble of the Constitution, namely social justice and upholding the dignity of the individual, your lordships. Now, your lordships, while deciding this issue of maintenance, your lordships, section 125 of CRPC is of great importance, your lordships, and lordships, I'll please refer to that section on page number 19 of my submissions, your lordships.
Yes.
Now, your lordship, in this case, the lower court has refused to give maintenance to the petitioner on the grounds that she is not a lawfully wedded wife, your lordships. To that, your lordships, on page number 20, in case of Abhijit versus State of Maharashtra, the Supreme Court, the apex court itself stated that it is not necessary for a woman to strictly establish marriage to claim maintenance, your lordships. Now, your lordships, coming another case, your lordships, of D. Velaswamy. In that case, your lordships, the apex court gave certain conditions that if a woman is claiming maintenance, she must fulfill certain conditions, your lordships. The conditions have been mentioned here, your lordships. They are of utmost, they're of great importance, your lordships, and hence I would like to read it, your lordships.
Yes.
Lordship, the first condition is that the couple must hold themselves out to the society as being akin to spouses. Second, that they must be of legal age to marry. The third is that they must be otherwise qualified to enter a legal marriage. And the fourth one, your lordships, that they must be voluntarily cohabited and held themselves out to the world as being akin to spouses for a significant period of time. Your lordships, the petitioner fulfills each and every conditions here, your lordships. Now, your lordships, another case of Tulsa versus Durgatia, your lordships. In this case, the Supreme Court provided legal status to the child born out of a live-in relationship, your lordships, and provided a condition that a crucial precondition that a child born out of a live-in relationship would not be treated as an illegitimate child if the parents have lived under one roof and cohabited for a considerably long time for society to recognize them as husband and wife. And it must not be a walk-in, walk-out relationship, your lordships. The fact sheet makes it very clear, your lordships. Your lordships, in the same case, the court also granted the right to property to a child born out of that living relationship, your lordship. So the issue of inheritance of property by the child is also clear now. Your lordships, in case of Bala Subramaniam, the apex courts held that if a man and woman are living under the same roof and cohabiting for some years, there will be a presumption under section 114 of the Evidence Act that they live as husband and wife, and the children born to them will not be illegitimate, your lordships. On page number 21, your lordships, of my submissions.
Yes.
Your lordships, in case of Dhanulal versus Ganesh Ram, again, the apex court decided that couples living in a live-in relationship will be presumed to be legally married, and it was also held that the woman in the relationship would be eligible to inherit the property after the death of her partner. So, your lordships, the issue of inheritance of property by the wife also is clear now, your lordships.
No, just a moment.
Yes, your lordships.
Is he divorced in this case?
Your lordships, he is
the respondent, because unless the respondent is divorced, she cannot be a wife because there's already a pre-existing wife. A mere live-in relationship cannot give her the status of a wife if an earlier wife is still in existence.
Indeed, your lordship, indeed, yes. That she, in 2010, as the fact sheet said, that they were legally separate. Legally, your lordships, judicial separation does not lead to divorce, but legal separation is divorce, your lordships. The fact sheet itself states.
All right. Okay.
Lordships, in case of Kamla versus Mohan Kumar, your lordships, in that case, there was a long cohabitation between man and a woman that led to presumption of marriage, entitling the maintenance for woman and the child born to them. Your lordship, it is again the case decided by the apex court, and it's a very latest judgment. I guess it's 2019 on, your lordships.
Yes.
Your lordships, may I please proceed to the fourth issue?
Yes.
Thank you. Oblige, your lordships. Your lordships, coming to the fourth issue, that whether Anvita the petitioner is entitled to the share of profits arising out of the drama school, your lordships. Your lordships, Anvita, the fact sheet itself makes it very clear that Anvita and the petitioner and the respondent, both of them had started this drama school as a joint venture, and both of them contributed equally from their savings, your lordships. So there is no reason that she should not get her share of profit, your lordships. To conclude the issue to be precise, your lordships. Your lordships, it is necessary to be stated here that the profit the issue of profit from the joint venture should be taken as a separate issue from the issue or the amount received by the petitioner as maintenance under section 120 of the CRPC, Your Lordships.
So under which provision are you claiming this share?
Your Lordships, the
Under which
principles
provision
of,
of law are you claiming this share?
Your Lordships, the principles of equity only suggest that if there is a
Equity,
joint
see, 1
venture,
minute. See, equity comes to the High Court. Your application is before the learned judicial magistrate under the provisions of the Domestic Violence Act. Now, under which provision of the Domestic Violence Act are you claiming a
under
share
the
in the
dom-
property?
indeed, Your Lordships, the share of profit is not in this domestic violence act. The issue of maintenance is in regard to the domestic violence, but this
Yes,
is
but
just
the share.
this is the
So where are you claiming this share of profits? Whom are you claiming it before? You have approached the learned judicial magistrate who has no power. He is not a civil judge, so he cannot give you a share in a property or a share of profits. So
indeed,
you have
but-
approached him under the Domestic Violence Act. So under which provision do you claim this share?
Your Lordship, indeed, we couldn't go there. Yeah, we concede that we couldn't go there. So, Your Lordship, we have been here to the High Court seeking.
See, before the High Court, the issue is limited to what was before the lower courts, because in High Court you have not come in a writ petition, independent writ petition directly. You have come against the orders of the subordinate court, not granting the relief which you had prayed for.
Indeed, Your
To a
Lordship.
certain extent, here you have been granted that relief.
Please, Your Lordship.
All of you are a student of first year or last year?
Both, Your Lordships.
Fourth year. So CPC and CRPC has been completed in your course or not?
No, Your Lordships. CRPC is being dealt with right now, and CPC
And
will be dealt
CPC?
with in the second semester, Your Lordships. The coming
And
semester.
so CPC is yet to be studied.
Indeed, Your Lordships. Indeed.
No, you are doing well, but these are certain queries which arise, so we are just putting them.
Because it seems that this fact sheet is not prepared by a lawyer. It is prepared by a law student probably. Therefore, anyway, proceed further.
Yes.
Your Lordships. So just and now the fifth issue would be dealt with again by my co-counsel, Your Lordships.
All right. Okay.
Oblige, Your
Yes.
Your Lordship, the fifth issue is that can an order be passed by the family court in respect to the custody of the minor or not? Your Lordship, the issue of custody of a child is a separate issue considering which should be considered on the basis of material and facts available, and it is definitely different from from the issue of the maintenance that we are currently dealing. But the custody of a child is a matter of utmost importance, and it basically the life of the child depends on this matter, which is why we seek your permission, which is why under the provisions of the Guardians and the Wards Act also, there are broad guidelines available regarding the custody of the child. As the issue regarding maintenance, including that of the child, is pending before the High Court, it is desirable that the proceedings before the family court may not proceed as of now. Your Lordship, this is all we'd like to bring. Your Lordship, may I please proceed with my prayer?
Yes.
Yes, thank you, Your Lordship. Wherefore, in the lights of issues raised and arguments advanced and the authorities cited, we pray firstly to pass a residence order, either along with the respondents or separate from the respondent, pass an order for maintenance of rupees 80,000 per month for herself and her child, pass an order for inheritance of the property, pass an order directing the respondents to pay the share in profit along with the interest of 10% arising out of the drama school, also pass an order directing the payment of compensation for the sexual abuse where the petitioner has been subjected to, all of which is humbly paid before the courts. Or oblige, Your Lordships.
Yes.
Your Lordship, am I audible?
Yes.
The council would kindly like to address the bench as Your Lordships.
Yes.
Your Lordships, the councils are appearing on behalf of the respondents. Your Lordships, the councils would like to deal the matter in 4 issues. The first and the fourth issues would be dealt by me, and the second and the third issues would be dealt by my co-counsel. Your Lordships, if you kindly permit, I would like to take the issue 1 and issue 4 simultaneously.
Yes.
Your Lordship, the council would be dealing on the pure facts to ascertain the actual nature of the case before this honorable court. Your Lordship, my first issue deals with the jurisdiction of this honorable court. to entertain the aforesaid petitions together. And your lordship, my fourth issue deals with the custody proceedings going on simultaneously with the petition pending before this honorable court. Your lordship, now dealing with my first issue, I would say that my first argument is that the criminal writ petition number XXX11 of 2021 and XXX13 of 2021 can be tried together as they both arise of the same judgment. They could be tried together on the basis of case and counter case theory. Your lordship, case and counter case theory are frequently used in matrimonial disputes. Your lordships, this theory is based on the principles that if both the parties to a suit are similar, if the subject matter of the suit is similar, if they both have been judged by a same judge, and if the judgment is based on the objects mentioned in the petition, then this theory could be used. And your lordship, thus both the criminal writ petitions can be heard together. Also, your lordships, if both the writ petitions are heard by different judges, then there are chances that there might be conflict in the opinion of the judges. So, your lordship, it is only fair that both these writ petitions are tried together by the same judge as to avoid any conflicts in the judgments. Your lordship, my second argument is that civil writ petition number XXX1 from 2021 cannot be tried together with this criminal writ petitions. Your lordship, firstly, this civil writ petition is not at all maintainable because Section 19 of the Family Courts Act prohibits the appeal against the interlocutory order passed by Family Court. Your lordship, this order passed by the learned Family Court dismissing the adjournment application done by the respondent against the custody proceedings initiated by the petitioner is an interlocutory order against which the appeal is barred, and thus this writ petition cannot be maintained at all, your lordship. Your lordship, now I would like to deal with my fourth issue dealing with custody. Your lordship, in the present trends, these appeals are converted into writ petitions under Article 227. Your lordship, that also cannot be entertained by this honorable court because it would itself defy the object of the Family Courts Act. Your lordship, the Family Court Act was enacted to provide the sole objective of speedy settlement of the matrimonial disputes. Your lordship, also it provides only for one appeal and it expressly excludes the right of appeal at an intermediate stage. So your lordship, granting writ petition or this appeal would itself defy the object given by the legislature in enacting the Family Courts Act. So your lordship, this writ petition cannot be entertained by this honorable court. Also, your lordship, this case involves the rights of the child in it. So, your lordship, it is a cardinal rule that while dealing with any case having child's right involved, that the welfare of the child should be considered paramountly. Your lordship, while considering the rights of the child, human angles should be considered foremost before considering the legalist principle. Also, your lordships, the rights of the child should be given utmost importance while considering it, rather than given the importance to the rights of the either parents or the guardians. So, your lordship, allowing this petition would delay the custody proceedings, and thus it would be against the interest of the child. So, your lordship, I request this honorable court to reject this writ petition so that the custody proceedings could be dealt as fast as possible and the rights of the child are safeguarded. Also, your lordships, this both petitions cannot be tried together as the subject matters of this case of the both the criminal writ petitions and one civil writ petition are different. Your lordship, criminal writ petitions deal with maintenance, residence, then domestic violence, sexual abuse, etc. While the civil writ petitions deals with the issue of custody. Your lordship, both of these issues are different and thus they won't interfere with each other, and so custody proceedings can be gone on together. Your lordship, only one issue would interfere with each other, would be the rights of the child for maintenance. Your lordship, as soon as the custody proceedings are over and it is resolved that who will get the custody, the maintenance proceedings of the child can also be initiated. Your lordships, the tenets of these arguments are mentioned in the case of Srimati Usha Kumari versus principal family judge on the page number 33 of the memorial. So, your lordship, I humbly submit that both the criminal writ petitions should be allowed together under the jurisdiction under section 482 of the Criminal Procedure Code, and also writ jurisdiction under 226 and 227 of the Indian Constitution. And also, your lordship, this civil writ petition should be dismissed as soon as possible. Your lordship, highly obliged.
With your due regard, your lordships, the council would like to move towards issue 2 and 3. Much obliged. Your lordships, here the council would directly point out to the very basic facts of this particular argument. Your lordships, the fact proposition in para 3, line 3 clearly states that there was mutual agreement and they mutually wanted to marry each other, because of which they went into a different city and because of which they settled together. So, lordships, this brings us to the issue number 3, which is issue number 2, which is whether there was sexual abuse on the pretext of false promise of marriage. Your lordships, this phrase, that is false promise of marriage, has been used in so many arguments beforehand. Your lordships, this here council would like to interpret this particular phrase, which states that there are three objectives, your lordship. First of all, there should be a false promise of marriage by the respondent or by the person. Secondly, the petitioner should fall for that false promise, and then on that pretext there should be a sexual intercourse. So lordships, even if only these three objectives are fulfilled, can that situation be called as a false promise of marriage? Your lordships, in this particular instance, we can clearly deny, and the logical fallacy can clearly be pointed out, that when the fact proposition itself states, when the petitioner itself wanted to live together for the reason that they both wanted to marry each other, there is no question of false promise of marriage. Furthermore, your lordships, the petitioners have gone too far, asserting the fact that this can be covered under section 375 and also under section 90 of the Indian Penal Code. Your lordships, section 375 is such a grievous offense, such a grievous in nature, that it cannot be just put upon in such a manner, which is in this context very consensual. Your lordships, here council would also like to cite the theory of rule of interpretation, that is casus amicus. Your lordships, casus amicus clearly relies on a basic principle that when a certain established statute gives for a certain established definition, there cannot be any presumptions, because it also asserts the literal construction rule. So lordships, if at all we literally construe what is there in the section 90 of Indian Penal Code, that is misconception of fact, we clearly bring to this notice that there was not at all misconception of fact in this regard. Lordships, she was clearly happily living with the respondent for 3 years, and when there happened differences between the ideologies of both the parties, she happily went on to keep the proceedings in a manner wherein she could apply the grievous offences nature, and she could apply section 375 on the respondents, your lordship. So lordship, in this particular light, the argument regarding the sexual abuse and that could be totally denied. Lordships, furthermore, in a precedent, it has already been established that when the consensus of judicial opinion is in favor of the view that the consent of the prosecutrix or complainant herein has had a sexual intercourse, and when she is deeply in love with the respondent on a false promise of marriage and on a later date, she cannot claim that it is given under misconception of fact. It also, your lordships, it also clearly establishes the doctrine of estoppel. It also states that when I have asserted a fact in the beginning, I have asserted a particular proposition in the beginning, at the end, when because the circumstances are not in my favor, I cannot deny the same. So lordships, this particular instance, the council would like to rest this particular issue in this honorable court. Furthermore, moving towards the third issue, lordship, that is regarding the maintenance of the respondent and the child. Your lordships, this particular the petitioners have come in this honorable court by asserting the fact of section 125 of CRPC. Now, your lordships, section 125 of CRPC clearly defines the definition of wife, which the council would not like to read out here. Your lordships, the council would also like to bring out again one more logical fallacy that the petitioners have highlighted by their own arguments. Your lordships, that is that explanation 4 of the same section, that is section 125 CRPC, clearly states that when a wife or when a woman has gone and left the husband without a reasonable cause and for a sufficient time, she cannot be therefore granted maintenance. So lordships, even if in this argument, even if we are asserting the fact that she is a wife of the respondent, which we are as of now not, but even if that is to be considered, that also would be negation to the petitioner's arguments, your lordships, because it clearly states the petitioner for 2.5 months for 90 days, period of 90 days, without any prior notice, without any sufficient cause, goes out of the house, lives to a particular place, and comes back to after 90 days without any sufficient enhancement, your lordships. So in this particular instance, if we are to construe this relationship in the nature of marriage, there has to be sufficient cause of why she went there, what were the reasons implying the same, and that thereby can the issue of maintenance be taken off, your lordships. That is clearly defined by the law, which states under explanation 4 of section 125. Your lordships, thereby contending that as your lordships had pointed out, that the respondent was not divorced when the relationship had began. Your lordships, that also can be construed as there have been many precedents that have cited that when a particular relationship is when a particular marriage exists without the decree of passing of divorce, in that particular instance, if a relationship comes in hand, that relationship and the person thereby, that is the girl in that relationship, cannot be termed as wife. So lordships, in this particular instance, the council would like to rest the case with the issues cited and would like to further move to the prayer if your lordships do not have any query beforehand.
Yes.
Much obliged. Your lordships, the respondent here honorably praise in front of this honorable court that the petitions, that is 11/2021 and 13/2021, be tried together, and discard the petition that is 15/2021 in front of this honorable court for the cited reasons, to hold the decision of lower court in the matter of the sexual abuse on pretext of false marriage, and to uphold the adequate reasoning provided to not grant compensation in the said case, or provide any other relief that this honorable court may be pleased in justice, equity, and good conscience, for which the respondent is duty bound forever play. Much obliged, Your Lordships. It was a pleasure arguing before this court.
Yes.
Your Lordship, may I proceed with the rebuttal?
Yes.
Your Lordship, first to clear out a few facts. The petitioner was not available for 70 days, and it was not without any notice. She had gone to her sister's wedding, which is very much a reason to get out of the house and not be present. Also, Your Lordship, we live in a patriarchal society. A man's willingness to marry a woman matters more than a woman's willingness to marry a man. So when the respondents have said that both of them equally wanted to marry, I would like to point out that a man's willingness, if he's not willing to marry, then what can a woman force? It is a patriarchal society. This is my contention. Also, Your Lordship, the respondents have not discussed a very important matter of the share in profits. They have not even mentioned about it in their written submissions, and in fact, that is one of the writ petitions that they have filed. So, Your Lordships, we wish that you look into the matter.
Yes.
Your Lordships, can the council proceed towards the rebuttal?
Yes.
Much obliged. Your Lordships, coming to the very first issue, that the patriarchal society that we live in, Your Lordships, considering the 21st century and the movements that have been going on, the feminists would definitely be offended right now. But nevertheless, Your Lordships, if considering this issue, Your Lordships, it is not just the responsibility of the respondent. They have mutually agreed to live together on the pretext of marriage. So I, as a respondent, I am the one who is supposed to go to the person, ask her out for the marriage, and she is on the discretion of saying yes or no. So in this circumstance, Your Lordship, I have no choice at all. Secondly, coming to the point of maintenance, Your Lordships, now, as has been established by the fact sheet, the amount is 1,50,000. Divided by 2, it is 75,000 each. And now the petitioner is asking for 80,000 maintenance. So, Lordship,
there is a child involved. There is a child involved.
So respondents, Your Lordship, the respondent. Yes, I understand, Your Lordships,
but
considering the financial limits, Your Lordships, the 75,000 is the share of the respondent. So now the respondent himself will have to take maintenance from someone else.
Just a moment. She is claiming maintenance for herself and the child also.
Indeed, yes, agreed. Your Lordships, respondents are not denying the fact, but Your Lordships, it has to be in a quantum. Now, if I am earning 75,000 a month, how can I give 80,000 a month to the person? That is what the honorable court has to decide.
Then you have to agree to pay 75,000 as a share.
Yes,
Your
Lordship.
If you are saying that she is earning 75,000 and you are earning 75,000 only, and how you can pay maintenance of 80,000? Then first of all, you have to set 75,000.
Indeed. Your Lordship, that is the very basic reason why the respondents have not cited the share of profits, because respondents here are here because, Your Lordships,
it's on a lighter side. Anyway.
Your Lordship, they have not discussed the matter only. They are not presented the matter.
That is the reason why the respondent is citing that aggrieved by our orders. So, Your Lordship, I am not aggrieved by the order of sharing profits. I am aggrieved by the maintenance part, Your Lordships.
I think one more team is there. 7-1 more team probably is there.
No, this is the last team.
So, Lordships,
last team. Okay.
Yes. Lordships, just concluding what the petitioner has cited, that this is the whole instance, and Your Lordships, there were also legal fallacies that regarding the profits that the petitioners have kindly mentioned. So, Lordships, in this particular instance, it needs to be noted that here we are aggrieved on the basis of the sexual allegations that have been maintained, on the basis of the jurisdiction part that has been maintained. So, Lordships, it is in this light that we have come in this honorable court. We are okay, we are happy. That is why we have not taken this issue, because we are keen to share the profits, Your Lordships. And
but
after that issue, yes,
but
we are not, that is why we have not taken this issue, Your Lordships.
Orally,
I could not gather the petition. Okay. Your Lordships, with your kind permission, the council would like to raise the case. Much obliged.
Obliged, Your Lordship.
Lordships. Just a thing, Lordship, it is necessary to be noted that in this case, the law of estoppel works against them only because of the respondent, the petitioner altered her position. So now he is under the obligation that he should come and do this, ask out for the marriage, because he was the one who initiated. The law
The
of
principle of
estoppel
estoppel speaks contrary, your lordships, not
necessary to be
intervening in
noted.
this same situation. The principle of estoppel states that when I have asserted a fact in the beginning, which the petitioner has asserted that she wanted to marry, and later on she has denied herself and put allegations. So, your lordship, in this manner, the council here cited the rule of estoppel. Nevertheless, the petitioners would gather it later in. Thank you.
Oblige, Your Lordship.
Oblige, your lord.
Once the rebuttal is over and sir rebuttal is going on, A2 and both A2 cannot speak, right? It is against the rule. That is what I just wanted to highlight to the honorable.
Extremely sorry, ma'am. Extremely sorry, Your Lordship. Lordship,
Okay.
please. Thank you.
I request both the teams to leave the studio.
Yes, so now you want us to put marks in that seat? Probably Arsa will.
Our students are watching on the YouTube channel, sir and ma'am. So we request you to give some overview on the competition. Anything that you want to say on the competition?
See, the submissions were good, but one thing is, in these matters which arise, they should understand the basic proposition as to what is the scope of the jurisdiction of the authority before whom they have filed the initial petitions. So when they go before the judicial magistrate, they are invoking the jurisdiction under the Domestic Violence Act. So their claims have to be limited to that act and should be relatable to any claim made by them, should be relatable to a provision of the Domestic Violence Act. So we are not concerned with the larger issue of whether the child's custody, etc., because that is the matter before the family court. So far as custody of the child is concerned, we are concerned only so far as the stay granted, whether a stay should be granted or not, whether the application should be heard together or not. So basically, it is these issues which require to be addressed, and it should be more on facts and legal submissions than on the judgments. So basically, all of them did a good job. So nothing to, I mean, at that, they are still students, so we can't expect all that much. But what I wanted to say is you have to concentrate more on the law with which you are actually concerned, which is the Domestic Violence Act and Section 125 of the Criminal Procedure Code. That, of course, jurisdiction, etc., were required to be addressed, but basically that focus should be on the provision of the Domestic Violence Act, and each prayer has to be relatable to the provisions of the Domestic Violence Act. Otherwise, all in all of them were good. We just wanted to point this out.
Yes, Justice S.J. Shah, sir, anything from your end, sir?
I think what Arsaben has said is perfect, that all the students, all the participants have done well. They have tried their best to convince us based upon facts given to them. So what is required is to be more cautious while preparing this fact sheet, where something is mixed and therefore it could not be digested by anybody when we are listening to it. But otherwise, all the participants have done best. And so far as issues are concerned, no doubt jurisdiction is one of the major issues to be decided by any court. But clubbing civil and criminal issues together and making a fact sheet that a civil dispute is claimed before before magistrate would make a difference. So it would be better if such fact sheet is prepared properly under guidance of advocate or a judge. Otherwise, all participants have properly done it. Congratulations to all of them, because ultimately they are students. That's fine. Yes.
Okay. At the end note, I request our assistant professor, Dr. Forum, Ms. Forum Pandya, to propose a formal vote of thanks.
Thank you, Vidhi ma'am. It is indeed a matter of pride and privilege for me to extend a vote of thanks to the esteemed judges of the final round of the virtual Intra Moot Court competition 2021 organized by the Faculty of Law, GLS University, Honorable Miss Justice Harsha Devani ma'am, and Honorable Mr. Justice S.G. Shah sir, Madam and Sir, I extend my heartfelt gratitude to you for your august presence today. The pertinent questions raised by you to the participants has definitely helped them enhance their mooting skills, which shall be very helpful to them in their career as lawyers. I once again thank you from the bottom of my heart for being with us today. Your presence has definitely boosted the morale of our participants. I take this opportunity to thank our director, Madam Dr. Mayuri Pandya, who is the driving force behind all the activities of Faculty of Law, GLS University. I also thank all the participants for actively participating in the virtual moot court competition in its true spirit while giving a healthy competition to other participants. I also thank all my colleagues for their support in making this competition a success. Vidhi ma'am, thank you. Thank you one and all.
We are ending the session. Thank you so much, ma'am and sir. The
Thank you, sir.
mark sheet will be, Harsha ma'am, the mark sheet the Kunal bhai will bring with us, and the spreadsheet, sir, we will be able to see. So by that, we will decide accordingly.
Okay, I will enter the marks herein and forward it to you. Okay.
So should I hand it over to?
Yeah, Kunal
Yes,
bhai.
sir.
Yeah, yeah.
Okay.
Okay. Thank you so much. We have 4 categories. From this, we will decide. Thank you so much.
Okay. Okay. Asaman. Fine. Thank you. Mali Kapoor.
Okay.